Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on a 3-hour journey through Courtlandia today, starting with Magistrate Urich. But before I turn on his audio, Tim, thank you for gifting 5 memberships straight away. Great way to get the day started, and I very much appreciate that. Thank you.
Go ahead.
Yeah.
Can you hear the court, sir?
Yeah.
Thank you. Mr. Yang, you were present just a few minutes ago when the court explained the informal hearing process. True?
Yes.
Yes.
Thank you. So you understood the court's instruction that you must select from one of 3 options to protect your rights. Yes?
No.
So you have an
Okay.
interview?
Miss,
So
I hear a voice off the
Good
camera.
morning. Yes.
Okay.
Yes. I'm here with him. He had requested a Wolof interpreter.
Which kind?
A Wolof.
Spell that, please.
WOLOF.
And are you able to interpret for him?
No.
Okay. We will have to use what we refer to as language line. So please stand by and we will be with him shortly. Thank you.
So much.
It's going to be, I had her spell it, the language of WOLOL.
Thank you. Tell me when.
I'll tell you when. Thanks, Jim. Okay, that brings us to Ms. Brown. Only case numbers 26, be like Berkeley E 03091 and 091A. These are people of the city of Berkeley versus Nevaeh Brown. That's you, Miss?
Yes.
Thank you. Ms. Brown, you were present just a moment ago when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court's instruction that you must select from one of 3 options to protect your rights, yes?
Yes.
Thank you, Ms. Brown. The citation before the court was issued June 17th this year at about 6 minutes of 2 in the morning. You were operating a 2016 Nissan black in color on Woodward Avenue, M1, and in your wheelchair in the city of Berkeley. And at that place and time, you were cited for disobeying a stop sign. And at the point of the request of the officer, you were unable to produce a proof of insurance, and your electronic insurance verification came back negative. So one is a moving violation, disobey stop sign. The other is documentary proof of insurance. You may admit responsibility. You can admit and explain, or you can deny responsibility, and the court will swear the parties and start your trial. What do you wish the court to do for you?
I would like to explain.
You can explain, but you have to do so within one of those 3 contexts. So do you wish to admit responsibility and explain, or deny responsibility and explain?
Admit responsibility and explain.
Very well. So you confirm me to the court that on the date in question, you were operating a motor vehicle in the city of Berkeley. You disobeyed a stop sign and were unable to produce a current valid proof of insurance for the officer at request time, correct?
Yes.
Thank you. The court accepts your plea. What would you like the court to know?
Okay, so at the time I passed the stop sign, I was genuinely not trying to pass it. It was dark and I was pulling out of a liquor store at the moment. So it wasn't like I was driving and speeding and passed it. It was just, if you know that area is really dark and like the street lights is really dim, and I just didn't see the stop sign at the moment because I was pulling out of the parking structure. And at that time, that the police is like really hot. So they just seen me and I was the only car on the road. So they just probably thought like, oh, she's violating. But I just didn't see the stop sign. And it was a short stop sign. It wasn't a tall stop sign. It was a little stop sign.
Are you suggesting, do you believe in some form or fashion the police department was picking on you, or I'm not sure what you're trying to say?
In some cases I may say yes, because there were 2 police officers like at the same area. Like I seen one drive past me as I was getting pulled over. So I can say it was a very hot time at the area. And like I said, I was the only car on the road and I didn't see a stop sign that I just passed. So clearly they seen something I did not see.
Okay. Fair enough. And do you have a valid proof of insurance you can display to the court today?
Yes, sir.
If you could just hold that up to your device so that the officer might be able to see it.
Figure out how to switch the camera. Okay. When you're able to see it, let me know if I need to move the camera or not.
Can you bring that in a little closer and say your name? Because you're pretty dimly lit over there. Move it slightly over to your right. And Sergeant Children, are you able to make out that proof of insurance?
I'm not able to, Your Honor, but if you can, I trust in you.
Okay. Let's see.
Yes,
You
yes.
do the Court of World of Good, Miss Brown, if you could turn on the lights where you are.
Yes, I'm about to actually get a light now.
That makes a difference. And could you bring it in a little closer, please? All right, my eyes are still not picking it up. What about you, Sergeant?
I can move if it's needed.
Can you maybe zoom in a little, ma'am?
Um,
Just on the expiration date is all I'm really
oh,
concerned
expiration
about.
date. Okay. It's right here. I'm trying to get a clear view.
I see 27, Your Honor. I'm good with it.
Very well. Okay, so with respect to the proof of insurance, any motions, Sergeant?
We can waive that one, Your Honor.
All right, that one is dismissed. And what, if anything, do you want the court to know about the stop sign? Sergeant.
I'm sorry, Your Honor. Actually, can I make a motion to the disobey stop sign is a moving violation, correct?
Correct.
Do we have a driving record on hand? Do you have one?
The court can take a look. Ms. Brown, the court wants you to know it has not examined your driving record until this moment.
Okay.
So let's see here. The last violation was a limited access speed out of the 36th in October of 25. Other than that, there's just a non-hazardous MVA.
Okay, Your Honor, I make a motion to strike the disobey stop sign and keep the no proof for insurance, because at the date of the infraction, there was no proof for insurance and EFV was no, but I do appreciate the taking care of it since then.
Okay, so Ms. Brown, what the officer is suggesting is he's dismissing the one of these two tickets that carries points. And with respect to your proof of insurance matter, as you appear to have not had proof of insurance at the point of time, the court is going to stand by. Assess a fine of $175. That is payable through the pay portal on the 44th District Court website. Or Ms. Brown, you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30, and that's going to be due within 14 days. That completes your hearing. Good luck to you. Be safe out there.
Thank you.
Good morning once again, everybody. It is TCF Live on a Tuesday. Thank you all for joining me. I hope your day is off to a good start. Barbara, 16 months with us. Thank you for being a channel member for 16 months, and thank you for everything you do for the channel. And you also left a $5 super chat. Dan, thanks for 16 months of great court and the best community on YouTube. Love to all at TCF. Also prayers for my family, please. Yes, do keep Barbara and her family in your prayers if you would be so kind, if you are a prayerful person. All right, slower start in the courts. I'm still waiting for things that interest me other than the magistrate, so we'll continue here for a little while.
Go ahead and call language and figure that out.
Good morning again, Your Honor.
Good morning. Calling case numbers 26B like Berkeley E03639 and 639A. These are people versus Jordan Christina Harrison. Miss Harrison, that's you?
Yes.
Miss Harrison, you were present earlier this morning when the court explained the informal hearing process, correct?
Yes.
Thank you. And so you understood the court to instruct that you must select from one of three options to protect your rights. True?
Yes.
Thank you, Ms. Harrison. The citation before the court was issued on July 15th. This year at 7 in the morning, you were operating a 2018 GMC black and color on 11 Mile Road at or near Stanford City of Berkeley. At that place and time, you were cited for failing to yield with an accident, and at that episode, while it was in play, you were unable to produce a valid and current proof of insurance. The notation from the detective on your citation indicates initially hit and run investigation, driver admitted accident, provided her ops, insurance expired at time of accident. So this is one moving and one non-moving violation. You have your three options. You can admit responsibility, you may admit and explain, or you can deny responsibility and the court will swear the parties and take your testimony. What do you wish the court to do for you?
I can submit and explain. Well,
Okay,
yes.
I'm sorry. The court's just going to do that in two steps. You're fine.
Okay.
So
Sorry.
you're confirming to the court that on the date in question, you're operating a motor vehicle in the city of Berkeley. You failed to yield, made a contact with another vehicle, and were unable to produce a current proof of insurance. Correct?
Yes.
Thank you. The court accepts your plea. Okay, Ms. Harrison, thank you. Didn't mean to interrupt. Keep going.
Okay. So yes, I did hit the lady, and I was a little nervous like around the scene. So like I didn't know like what to do since I just got my license, and like I never been in situations to where like I had hit anybody or somebody hit me. So I was just nervous and I left the premises and I went home.
Approximately how far had you gone before you made contact with any public safety officer?
Well, like the miles, are you asking? Or
Yeah, sure.
I would say I think it was like 35 miles per hour, I should say.
And what was the distance between you and this motor vehicle accident you were in when you finally encountered the detective?
So before I hit her, I was in a parking lot and I was waiting to turn where I was supposed to go. And when I seen that it was clear for the other driver to come into the parking lot, I was like guiding her to proceed with her destination. But I guess she was a little nervous that she didn't want to get hit. So I just let her sit where she was at, but it was free for me to go where I was going. So I turned, and then and I didn't know I was gonna hit her until I heard something from my side of the vehicle.
Okay.
And she beeped her horn. I thought it was for another car, and then I left. But like I said, I got a little nervous, and I didn't know what to do after that.
All right. Thank you, Ms. Harrison. Court appreciates your remarks. Detective Gothard, anything? Oh, before I go any further, do you have a proof of insurance that you can display to the court today?
I think my mom has it right now because I'm at work.
Okay. All right. No problem. Detective Gothard.
Your Honor, it was actually 5 days after the accident when I was able to identify her. She was forthcoming about being in the accident. She was nervous. I told her that if she made an informal hearing on her own, came in front of you, that I would try to help her out. So what I'd like to do is I'd like to amend the ticket to impeding with an accident, and then also dismiss the no proof of insurance charge.
Very well. Ms. Harrison, it sounds like you've done the right thing in terms of what they refer to as redemption. So, impeding with an accident is a non-moving, non-recordable offense. It will not show on your master driving record. That's acceptable to you?
Yes.
Thank you. So your original plea will subsume the plea to impeding traffic. The fine is $220. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. Court's going to mark that one due within 21 days, and the case ending in the suffix A is dismissed. Good luck to you. Take care.
Okay, thank you.
Thank you, Your Honor.
Thank you, Detective. All right, stand by, Sergeant. We're trying to work with language line here for your final.
Understood.
Alrighty, friends. Will they find an interpreter? Let's stay in Michigan, but let's go over to St. Joseph County. Say good morning to Judge Middleton.
That little holding cell is not very adequate. All right, Mr. Howard. Take the responsibility, no drugs, no alcohol. I hope everybody else isn't a no-show. Let's see who else came in. A lot of people came in and didn't end up on the list. Started out kind of a herky-jerky start. We got 3 bailiffs up here now. Aiden Black, we've already established, is not present. 261395. Mr. Black has. $355 with unpaid tickets. Let's see if. All right, Casey, here's the jail. Good morning, Mr. Anthony. This is Judge Middleton. Your lawyer, Ms. Strong, is here with me at the courthouse. She wants to speak with you privately in a breakout room, and I'm going to set that up now.
Okay.
So click the button that says join, and you should be good.
For me?
Yeah, I went in automatically. All right. All right, as for Aiden Black, even though he owes a bunch of money, this is his first fail to appear. Try in order to show cause. He does live in Three Rivers. Charge is a driving charge. It's easier to do in order to show cause than to have somebody tracked down and arrested, especially if they show up on it. He owes $365. Good morning. Are you Alyssa Klusterman?
Yes, Your Honor.
We've met, at least by Zoom. I'm Judge Middleton. You're here on a charge of Three Rivers Ordinance disorderly person. That is a misdemeanor. Thank you. Thank you very much for your help. It is punishable by up to 90 days in jail and a fine of up to $500. Let's take a look here for a minute. You're in jail. and been in jail. I looked at this yesterday. See how much jail credit you got. "13 days. Now, disorderly person, we had someone just a few minutes ago that pled to that charge. Basically, it's causing a disturbance in a public place in the city of Three Rivers. It's alleged that this happened on April 23rd, 2026. According to Mr. Reed, he met with you and you've agreed to plead to this charge. He's going to recommend a minimum fine and time served. So if I will follow his recommendation, meaning if you plead guilty to this, I'm going to fine you $125. I'm going to give you 13 days in jail, credit 13 days. Do you have anything else holding you in custody?
No, Your Honor.
All right, let me explain a couple other things. Do you understand that if you do plead guilty to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Jackson is here with you from the Public Defender's Office in advisory capacity. But if you wish to have an attorney, I could appoint one for you. We could have a trial. But if you plead guilty to this, there won't be a trial. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
And again, I don't remember, did anyone threaten you to get you to plead to this
No, Your Honor.
or promise you anything?
No, Your Honor.
We had several of these earlier this spring and summer, mostly on Main Street. Reggie King was in some of these. Elizabeth Conway, you guys were living on the street downtown. Let me see what it is you supposedly did. Yeah, there's a video of you, I'll just read, peeing in the flower garden in the middle of the alley. And then you pulled up your pants, got on your bike and left. So that's the allegation. You accept that?
Yes, Your Honor.
That probably isn't merit 13 days in jail. I think you failed to appear a time or two. And I don't know what they set the bond at, $200. You failed to appear in May. And so I issued a bench warrant, set the bond at $200. Where are you gonna go if I let you out of jail?
I have a home now, Your Honor,
Where's that?
on 7th Street,
What's the address?
715 7th Street.
All right, we've had a number of problems at that house. Who lives there with you?
Janie Hay.
All right. Where are you from originally?
Originally, I'm from Mendon.
You don't need to be in jail any longer for this. 13 days jail credit, 13 days. 0 fine, but I have to order $125 costs. I'm gonna give it until September 30th to pay that. That's about 2 months. If you need more time, you come see me. I could have just leave you in jail for 2 more days, but I just soon lay you out and see if you can pay the minimum court costs. Have you got a way to get back to Three Rivers? Will somebody come get you?
I'm not sure yet.
Do you need a bus pass?
Repeat that again.
Do you need a bus pass? I could give you a bus pass to get from the jail back to Three Rivers.
I have a tablet. I just need to connect it to Wi-Fi.
Okay. For the bus.
No.
Only the best. Pick you up the gym, take it through.
I have a sister who lives in Centerville. I have a sister who lives in Centerville.
Oh, okay.
All right, well, if you need a bus pass, you can't get a ride, walk from the jail up to here and the bailiffs can give you one to get you there. All right, Ms. Kloosterman, you're gonna go to jail. Obviously, this kind of thing goes to the quality of life for everybody in Three Rivers. Hopefully you get a better situation than this. They were really upset about this earlier in the spring about people doing this kind of thing downtown. So you're good to go.
Thank you, Your Honor.
Well, he grabs the next contestant. Gigi sent us $10 over at courtroomfiles.com. Says TCF, where smart people go for interesting court cases. Thank you, Gigi. I very much appreciate that.
Let's see here. So, is Wesley Halsey here? Nija Jones? All right, I'm just checking, I'm taking roll right now. Is here. Cody Marshall is here. Teresa Torres? Not here. Yvonne Williamson? All right, we have 2 more people that are here. Miss Christensen or Miss Lauman, why don't you come back up while we're waiting for our next guy? All right, the prosecutor has agreed to dismiss the no insurance charge altogether. That will save you $325. And you would plead guilty to driving without your license in your possession.
Yes, sir.
That's a misdemeanor. It carries no points. It is punishable by up to $100 fine plus costs. And I must confess, I do this crime several times a year when I drive away from work and leave my wallet in my desk. I don't have my license in my possession. Then I come back to work and get it. Are you willing to plead to that remaining charge if the other charge is dismissed?
Yes, sir.
Anyone threaten you to get you to do that?
What was that?
Anyone threaten you to get you to do that?
No, sir.
All right. You were sitting there patiently while I went through the advice of rights just a minute ago. Understand you're giving those rights up by pleading to this?
Yes.
All right. I'm going to reduce the fine to $75 plus $125 of cost. That's $200 fine. Can you pay that today or do you need time?
Not today. I didn't bring no money with me. If I could have the 30 days, if I
All
could,
right, I'll
please.
make it due by September 30th. Take cash, certified check or money order, and pay by credit card. Here's an envelope if you want to mail in the check.
Thank you.
And you're good to go. This
All right.
won't put any points on your driving record. It will show up on there. And it is a very minor misdemeanor, but you're good to go. The insurance charge, the expensive one, is dismissed. So good luck to you.
All right, thank you very much, and have a nice week.
All right, thanks. Thank you to Prosecutor Canfield for helping us with that. Good morning, Mr. Collins.
Middleton, how you doing,
You're charged with driving suspended.
Yes, sir.
You've been in jail 33 days.
Yes, sir.
You got some other charges that are holding you in custody. But Mr. Reed recommends I simply give you time served for this and call it good. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record, and it requires that your license be suspended. I don't have any control over that. That's from the Secretary of State.
Right.
You got 33 days in jail. I represent that I will follow Judge or Mr. Reed's recommendation for a sentence of time served and a minimum fine. Is that acceptable to you?
Yes, I'm trying to get my license upon getting out of jail. I'm going back, get my license back. I haven't had my license in several years, and I shouldn't have been driving. But yeah, I agree with it.
Okay. Anybody threaten you to get you to plead to this? What do you need? You can have all of it. Thank you. All right, I went through the rights a minute ago, but you weren't in here, so let's repeat it. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There won't be any trial if you plead to this driving suspended charge. You understand?
Yes, sir.
If you had a trial, you'd have the right to have an attorney. I could appoint one for you, or you could hire an attorney of your own choosing. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
All right, they say this happened in Three Rivers on June 4th. You were driving a motorcycle at that time?
Yes, Your Honor, right there in West Michigan.
And you had somebody on the back?
Yes, I had my wife on the back, sir.
And you didn't have a valid driver's license, it was suspended.
Yes, sir.
All right, now we can take care of this. You seem really good today. Sharp, paying attention, listening. 33 days in jail has probably helped you get your head on straight.
Yeah, and being me and my wife are newlywed. We were just married June 24th, and I'm really trying to give my life wrapped around her and better my life for her, you know, so, me getting out here and getting my license back, and I know they're suspended right now, but there's the goals and stuff that I need to get out there and to take care of. I'm trying to put her back in school and stuff, so yeah, I'm really trying to be a better husband.
Well, that's a worthy goal.
Doing stupid stuff like that is not gonna make me a better husband.
Guess we could all work on that. All right, Mr. Krantz. You're originally a Sturgis guy, aren't you?
Yeah, I was in Sturgis for several years, and then I kind of migrated towards Three Rivers about 2005. I've been pretty much kind of Three Rivers ever since. Last job, I worked at Cavoni's for about a year.
I like Cavoni's.
Yeah, but I get out of there, I get out of jail, I'd like to go back to American Axle, whatever the name of it is now, but that's where I would like to go back to, better paying job. But Frank and Kathy are good people.
All right, 33 days in jail credit, 33 days. The minimum fine of $125 or 2 additional days. This is going to be concurrent with your felony charge. So basically that $125 is going to get swallowed up by the time you're doing on the other case.
Okay.
But this matter is over. You do now have another driving suspended on your driving record, which will delay your ability to get your license back. But this matter is resolved.
Thank you.
Okay. All right, I think that's it for our in custodies. Casey, is Mr. Anthony the only case you had?
Yes, Your Honor.
Good morning once again, everybody. It is TCF Live on a Tuesday. Thank you all so much for being with me this morning. I appreciate it. Let's go down to Florida, check in with Wade Mercer.
Yes, is Terry Lee. Mr. Lee, good morning. Mr. Lee, you're here for first appearance because you've been accused of driving with no valid driver's license. Mr. Lee, you also have a possible violation of probation charge coming out of Calhoun County, possibly. I'm going to appoint the public defender's officer to represent you. I'm going to tell you there is probable cause in the complaint and that I have looked at your criminal history, and I'm going to ask that you listen to the attorney and we'll go from there. Mr. McDaniel.
Your Honor, I spoke to Mr. Lee. We're going to have no contest. The charge is listed. You understand he'll be sentenced to 60 days in the county jail, 1 day jail credit, $400 fine. He has waived his right to jury trial and call witnesses. His plea cannot be used against him in any violation of state probation. The incident can be used, but not the plea itself.
Thank you. Mr. Mitchell.
That is agreeable with state, Your Honor. We just request that you put a 7-day hold in for case number 2644CF.
Okay. Mr. Yeah, since he's entering a plea, it really isn't necessary, but they'll have the whole time to place a hold on him if they want. So, Mr. Lee, did you hear that agreement, sir?
Yes.
Mr. Lee, do you have any questions about that agreement?
No.
Sir, is that the plea you would like to enter?
Yes.
Mr. Lee, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license. The judge you guilty of that offense, find it's freely and voluntarily entered with the advice of counsel. Sentence you to 60 days in jail. Give you credit for the time that you've already served, which is 1 day. Mr. Lee, I am going to impose the court costs and fines in the state and county law set amount of $400. Mr. Lee, there's a condition that this plea cannot be used against you in violation of probation hearing. If they try to do that, I will let you withdraw the plea. And Mr. Lee, hopefully you'll get you some game time. We'll see what Calhoun County does. I am asking Mr. Mitchell to notify them. I think it was Calhoun County.
It is Calhoun.
And we'll see. If they don't have a hold, when you finish this sentence, you'll be released. If they do have a hold, Mr. Lee, then what will happen is you have to honor that and you'll go down there and deal with any violation of probation if they accuse you of that before you're released. Any questions, sir?
Well, at the time, I just want to make this statement. I was headed to see my probation officer at the time of the incident.
Okay. All right. Any other questions? Have a good day. John Johnson is next.
Mr.
Johnson, good morning, Mr. Johnson. You're here for one charge, driving while license suspended or revoked knowingly. Mr. Johnson, there is probable cause for that charge, and I've looked at your criminal history also. Mr. Johnson, I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Johnson. He's going to plead no contest to the charges listed. The understanding he'll be sentenced to 30 days in the county jail, 1 day jail credit, $400 fine. He has waived his right to a jury trial and call witnesses that will resolve this case this morning.
Thank you, Mr. Mitchell.
That is agreeable with the state, Your Honor.
Thank you. Mr. Johnson, did you hear that agreement?
Yes, sir.
And Mr. Johnson, is that the plea you would like to enter, sir?
Yes, sir.
I couldn't hear what you said.
Yes, sir. He said.
Okay. So, Mr. Johnson, I'm going to accept that plea of no contest to the charge of driving while license suspended or revoked, sir. Going to find it's freely and voluntarily entered with the advice of counsel. A judge who guilty sentenced you to 30 days in jail based upon your criminal history, 1 day credit, $400 court costs and fines. Mr. Johnson, you don't have a probation hold. As far as I can tell, you're not on probation anywhere. So if that's the case and you're not wanted anywhere, then when you finish this sentence, you'll be released. No probation involved in this case. Mr. Johnson, also, you certainly may do less than the 29 days, just like Mr. Lee may, but that's something between you and the jail. You may be entitled to extra gain time. Just talk to the jail about that. Any questions, sir?
No, sir.
Wish you the best.
No.
Yes, sir. We have McKayla Monday next. Ms. Monday, good morning. You're here because you've been accused of 1 count of dealing in stolen property, 2nd-degree felony. Ms. Monday, there is probable cause in the complaint, and I think you're already out on bond and were on bond when this charge allegedly occurred. Out on bond in case 26-306 CF. Ms. Monday, I'm going to listen to the attorneys and I'll address your bond status. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
We just request the court revoke our bond in 26306 CF, given this new law charge.
Thank you. So, Ms. Monday, you're entitled to a bond in the new case. I'm going to set you one based upon it being a 2nd-degree felony and you're already being on bond. Your bond is $20,000, cash or surety. That bond has a condition of no contact with the alleged victim. Do not try to post it because you won't get out anyway, because I am revoking your bond in 26-306 CF. I'm asking Mr. Mitchell to give me an order to that effect, revoking that bond, and I'm going to ask Mr. McDaniel to notify your attorney in that case that you're in jail with no bond. That attorney should come see you. Ms. Monday, do you have any questions?
No, sir.
Wish you the best, ma'am. We do need to give Ms. Monday a court date, please, Lieutenant, for September 1st at 8:30 in front of Judge Garcia. That'll be your court date, ma'am.
Yes, sir.
Thank you. We have Sheena Turner. Ms. Turner, good morning, ma'am. Ms. Turner, you're here. Just let me finish this note on that last case so I can keep my notes straight. Ms. Turner, you have a violation of probation charge in Jackson County, accused of violating the terms of your supervision here, ma'am. I want to go ahead and get you arraigned, which means I want to get you a lawyer appointed if you're asking for one. Ms. Turner, would you like to have an attorney appointed to represent you?
Public defender, yes, sir.
Okay, I'm going to appoint the public defender's officer to represent you. Ms. Turner, listen to Mr. McDaniel, and then I'll see if you have any questions in just a minute.
Your Honor, we're going to enter to not guilty. Yes, to sit this on the September 3rd docket, and I advise that that an attorney from the PD's office will visit her prior to that hearing.
Thank you. Mr. Mitchell, anything?
Nothing from the state, Your Honor.
So Ms. Turner, he or she will see you before your court date, and you have no bond, at least right now you do. Do you have any questions?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. Alyssa Elmore. Ms. Elmore, good morning. You're here for a hold out of Bay County. Ma'am, what they're telling us is that you have charges down there of some type of accessory after the fact to an ag battery with a firearm and a failure to appear. Well, the first one's a violation of pretrial release. The second one's a failure to appear for that same charge, and you have no bond. So, Ms. Elmore, they'll pick you up. They'll be notified if they haven't already that you're available to be picked up. Ma'am, when they pick you up, you'll go to Bay County, and the judge in Bay County will address your bond status. But right now, they have no bond on these holds. Do you have any questions?
No, sir.
Have a good day, ma'am. Melanie Pollock. Pollock, good morning. Ms. Pollock, you're here in case 26-268 CF, accused of 1 count of perjury in an official proceeding. Ms. Pollock, There is probable cause in the complaint. But this charge allegedly occurred in January, so I need to double check and see if the charge allegedly occurred while you were on probation, because I know you're on probation.
It did. From what I saw, she pled to probation in October of last year.
Okay, Mr. McDaniel, were you saying something?
October of last year, she pled probation. Not sure when this incident happened, but.
Yeah, supposedly happened January 21st of this year. So let me listen to the attorneys, Ms. Pollock, then we're going to deal with your bond status. Mr. McDaniel, anything?
Your Honor, I don't have anything.
Mr. Mitchell.
We just request that you place a 7-day hold for the VOSP in those two cases, 25116 and 25425 CF.
Thank you both. So, Ms. Pollock, I'm going to set your bond on the perjury charge of $20,000 cash or surety. Ma'am, do not try to post that right now, because I'm going to do like I almost always do, and that is place a 7-day hold on you, ma'am. Ask Mr. Mitchell to notify the probation office of your arrest, and we'll see if they seek a warrant or not, ma'am. So I'll see you next, what's today, Tuesday? I'll see you next Tuesday, ma'am. If they get a warrant before then, I may see you before then, and we'll see if they have a hold, if they put a hold on you, or if they issue a warrant. If the judge does issue a warrant, that judge will decide if you get a bond or not. If they don't have a warrant issued by next Tuesday, then in all likelihood, I'm going to release that hold, and you'll be then free to post the bond in the new charge if you wish. But for the time being, you wouldn't get out even if you posted it. Any questions, Ms. Pollock?
Yeah, I'm saying, what warrant you talking about? If you said.
If there's a VOP.
What will happen is the probation officer will present a warrant to Judge Garcia. This is normally what happens, and say, Ms. Pollock has this new charge. Do you want to issue a warrant for her? Judge Garcia will then usually go read the complaint. She'll read the complaint from the perjury case. And if Judge Garcia feels that there's evidence enough to establish probable cause that a felony was committed, she'll sign the warrant. And she will also decide if she's going to put a bond on that warrant or not. Usually violation of probations do not have a bond. There are no bond cases, especially if they're based upon a new felony charge. That's why I'm telling you, don't try to post bond, because it's very likely if you post a bond, number one, you wouldn't get out because I put a 7-day hold on you. And number two, it's certainly possible that next Tuesday, I'm going to tell you, you've got a no bond warrant for violation of probation. But we'll have to wait and see what Judge Garcia says when she reviews everything. Any other questions?
Saying even if that event happened before I got on probation?
It did not. According to the Department of Corrections, you were on probation in October of 25, and this event happened in January of 26. Because you got to remember, the incident you're accused of is perjury, not the incident you allegedly lied about, but the actual day that you committed the perjury is the day the crime occurred. I know the incident that you allegedly lied about happened before you're on probation, but that's not what you're charged with. You're charged with perjury occurring in January. Make sense?
I can't.
All right. Wish you the best, man. We do need to give her a court date, please, of September 1st at 8:30. Thank you, Mr. Mitchell. Janelle Shemaiah Dubose. Mr. Bose, good morning. Mr. Bose, you're here for first appearance accused of 1 count of battery domestic violence. Mr. Bose, I've read the complaint in your case. There is no probable cause, ma'am. Excuse me, there is probable cause. Mr. Bose, it also looks like you have no criminal history at all. Is that accurate, ma'am?
Yes, ma'am. I mean, yes, sir.
And you are how old?
23.
And do you work or go to school or neither?
No, sir.
23 years old and no job and no school. Is there a reason for that? How do you live?
My mama gave me money.
All right. Mr. McDaniel, anything else on behalf of Mr. Bose?
Yeah, we just asked for a cash bond or a conditional release, whichever the court feels fine with it.
Thank you, Mr. McDaniel. Mr. Mitchell?
If she wants to post cash bond, we're not going to object to it.
Mr. Bose, your cash bond is $250 cash. You do have a condition of absolutely no contact with the alleged victim, Mr. Bose. And ma'am, you'll get a chance to use the phone in a few minutes to post that bond. The jail staff is also going to give you a notice for your court date, and that'll be when, Dawn?
31st.
August 31st at 9 a.m. will be your court date. Mr. Bose, no contact means no contact at all in any form. You cannot contact the alleged victim in any form. If she wants contact and if you want contact, then we'll consider that your court date. But right now, no contact. Any questions, ma'am?
No, sir.
Have a good day, ma'am.
If she just want was she taking?
She's cash bond.
She
That's all
took
she's
cash.
offered. I didn't offer
Oh,
a
okay.
conditional release, but unemployment
Okay.
and not in school. Mr.
Got it.
Couch, Decorate Couch, good morning. You're here for first appearance. Accused of one count of failure to return leased property over $300. Mr. Couch, there is probable cause in that case. I think I may have been the judge that signed the warrant. Looks like I was. It looks like your third arrest in 2026 alone. So you're probably not going to get a conditional release, but Mr. McDaniel did send an email, I think, or a text or email this morning. So I want to listen to him before I make a final decision. Mr. McDaniel?
I think he's been ordered through one of those other cases to go to Chrome. He's been in Chrome, I think, since May. So we're asking the court, if the court feels inclined to go ahead and send him on back to Chrome so he can finish that other order out, whatever the court required to do.
Thank you. So, Mr. Couch, I couldn't see where you were ordered to go to Chrome. The Jackson County case looked like it was jail time. The Bay County case looked like it was dismissed. Are you court ordered to Chrome? And if so, out of what county?
Through the court of this
What
county,
county? What county?
Jackson County,
Was it through a criminal case or was it through some other type of case?
through my own case.
Was it a criminal case? Are you charged with a crime where you're court ordered, or is it a substance abuse type case?
He don't know, Your Honor. I was going off what he told me the court ordered him to, so I didn't look and see it. I didn't actually look, but I know they had contacted me yesterday.
It was because I was at work at my job and I was stressed out and I was just trying to provide for my family. I needed to provide for my family. So, I
remember his mother was up here on our case and was wanting him to go to rehab, I don't know if they're booking him or not, or.
I'm just trying to find out if he says he's court ordered. I'm trying to find out who did it and when, because that's relevant. If he didn't make these payments to this rental company supposedly, and he was in a program court ordered, I'd like to know that.
Absolutely.
Because it may affect what I do today. But I don't see anything in Jackson County where he's court ordered to a program.
I didn't see anything in Bay County either.
There's a mental health case. Let me look at the misdemeanor disposition. I didn't order him. I think I'd remember that. The misdemeanor was 34 days in jail with 34 days credit. So that one's done. That was back in May. But there is a 2026 MH case. But usually you don't go to long-term inpatient on those. Ex parte order for involuntary assessment. And that was dated in March. So, Mr. McDaniel, I would let him go back to a program. If I knew more about it, knew who had sent him there and when and how long he had been there and things like that. I don't see where he's court ordered from what I'm looking at in Jackson County. So I'm going to set you a bond today, Mr. Couch. You prefer a cash bond, Mr. McDaniel? Does he prefer a cash bond?
I don't think it's gonna matter, but yes, Your Honor, that'd be fine.
Mr. Mitchell?
No objection to a cash bond.
Mr. Couch, your bond is $500 cash only. If you're able to give Mr. McDaniel some information about what judge sent you to the program, and I can look at that file and see how long you've been there and get some questions answered, I might consider letting you out to go back to that program. But right now, I don't see where you're court ordered. You're not court ordered out of Jackson County from what I see. Now, it's possible somebody spelled your name differently and it's not coming up under my system here. I don't know. But if I get more information, that may change. But right now, you've got a right to a bond. Your bond's $500 cash. You've got a condition of no contact with that rental center. And you're also going to get a court date for September 1st at September 1st or the 31st?
September 1st. Yeah.
September 1st at 8:30 is going to be your court date. Any questions, Mr. Couch? Have a good day, sir.
No, I got a question. So, you said if I remember who my judge was that ordered me to go to that rehab, could I possibly?
What do you just say?
Do you know who the judge was?
I walked there.
So did you go there voluntarily or were you court ordered to go there? That's the question.
Both.
Okay. What judge ordered you on the court ordered part then? How long have you been there?
It's been there about 3 months, Your Honor.
Mr. Couch, is that right?
Yes, sir.
Okay, Mr. McDaniel, if you can verify any of that, bring back up first appearance one day, I certainly will listen to it, but right now, that's his bond. I don't have any, I don't think he's court ordered at all. He can't even tell me the judge that did it. I don't think that's accurate. Have a good day, sir.
Hang on, I got Ms. Colworth calling me right now. Let me see what she's gonna say. Hey. So Ms. Colworth just told me that he went in voluntarily to Chrome and he's been there. I'm gonna ask her, it's been since May, but he voluntarily went in there. And I don't know if you see my text message, but you remember he was here that month or so. He never said a word to anybody. He's got some issues, I think, and he's been there since May, she said, and doing well.
Okay,
He don't talk.
All right, so given that, let's go back and look at the case, because I think part of his non-payment and not returning this property may have occurred while he was in a program in Chrome. So let me see what the complaint says in the current case. 26-432 CF. This contact's giving me trouble. 26-432. Something right. Okay, I see the problem. Part of the problem, there's a spacing or hyphen in your first name, and the clerk system has it entered 2 different ways. So let's see if I can find the other case. Man. All right, Mr. Couch. These allegations allegedly started in August. That's when you supposedly rented the item. Let's see what the item was. A game system, PS5, console, made payments through March of 26. That's good. And then at some point, your rental payment stopped. And they were unable to contact you. In July, they sent you a demand letter, but from what I'm hearing, in July, you were already in a treatment program. And that's why you're accused of failure to redeliver the personal property, the leased personal property, after the written demand. But there's certainly evidence you didn't get the written demand because you were in a treatment program voluntarily. So, Mr. Mitchell, what is the state's position on some type of release option requiring him to go back to that program?
The state has no objection.
Mr. Couch, is that what you want to do? Do you want to go back to that program that you were in yesterday?
Yes, sir.
Do you feel like you're making some progress there?
I mean, I was, and I do feel like I am.
Okay. Mr. McDaniel, anything else?
Nothing, Your Honor.
I'm going to give you the option of a conditional release as an alternative to that cash bond. The conditional release would have one condition. That condition be that you successfully remain in that program. So you have to stay in the program, follow their rules. As long as you do that, then you'll be out on conditional release. You won't have to post a bond. Is that what you want to do, Mr. Couch? You want to go back to that program, right?
Yes, sir. Yes, Your Honor.
Okay, so Mr. Couch, let me ask you this question. Actually, it's not for you, it's for the state. So I don't know, we want to give him the normal court date of September 1st, because I don't want him leaving the program just to come down the street 3 miles to be told state hasn't filed charges yet, because it's pretty new. That's a pretty short turnaround for y'all. Mr. Mitchell, what court date would you like him given? September or October, or a different one?
I wouldn't object to an October court date. And if he's still in the program at that time, I'll let the judge know and I'll let Mr. Gill know too, and we might be able to work something out.
What's the October arraignment date? Mr. McDaniel, you okay with that?
Yes, Your Honor.
Mr. Couch, the judge will give you a notice for October 6th, 2026 for your arraignment date, but if you're still in the program, then that program director or whoever's helping you out there needs to contact I'll contact the public defender's office a week or so before the court date and say, Mr. Couch is still in the program. He's doing well. And does he still need to come to court? Because a lot of times they don't want you leaving a program if you're doing well just to come to court for 2 or 3 hours and go back to the program. A lot of times they'll just postpone the court date. So make sure you stay on top of that. They'll give you that written notice for that court date before we leave. Did I put the court date on the record? Mr. Couch, any questions?
So when I come back to this first appearance on
October 6th.
why not September 31st?
They give you some more time to stay in your program.
Because if you're doing well in the program, I don't want to cause problems with you completing that program. I want you to keep doing well. That's why I'm not wanting you to come back that early. That's September 1st is just 3 weeks from now. That's why I'm passing it to October. Now, if you want September, we can keep it in September, but the program's not going to want to be bringing you back and forth to court either if they can help it.
All right.
Okay. All right.
They see
That's
October
fine.
6th. May not, so you're still in the program.
Yeah,
may
you
not.
still have the no contact condition on the conditional release. So that is a condition of the release. So he's not going to be on a formal reporting release. No, I just want the sole condition be successfully complete the program, no contact the alleged victim. And then if he gets out of the program, what will happen? If you complete it, you'll come back to court and we'll deal with his status then. Hopefully the criminal case will be over by then. I see the program needs to notify. I guess, how do we usually do it? Well, the program knows that he's got to complete the program and they notify you if he doesn't, if he leaves. We've got to put him on formal release to do that. They're not going to know if we don't have anything in writing, are they? So what's going to happen, Mr. Couch, is they're going to bring you to the courthouse to meet with Mr. Goods, and he's going to go over that release with you. So I'm not going to pay any supervision fee or anything like that. I just need you to report that program, stay there, follow their rules, don't get kicked out of the program, and then we'll see what happens with the criminal case. Okay?
Yes, Your Honor.
Have a good day, sir. I wish you the best.
Will y'all go ahead and bring him up this morning, sir?
Yes, sir.
Thank you.
Thank you, Mr. McDaniel, for helping me figure that out. Once I learned that he had been in the program and verified it, that was helpful. That's everything I had this morning. Mr. McDaniel, anything else from the public defender's office?
Nothing on the record, Your Honor.
Alrighty, everybody, entering hour number 2 of TCF Live. Gigi, thank you for gifting 5 memberships. I appreciate that very much. And oh, by the way, Gigi, if you hit refresh on your Court Watch screen, so refresh it, your chat should work now when you're playing bingo. Who codes and streams at the same time? This guy. Got it fixed for you. Okie dokie, let's go to Nevaeh County, Michigan, Judge Springstead.
Thank you. All right, first up will be David Carl Johnson, case number 26137121. All right, we're set for sentencing today. Prosecution and defense was the pre-sentence investigation report timely made available to?
Was, Your Honor.
Yes, Your Honor. And Ms. Frisbee, have you had the opportunity to read the report and discuss it with Mr. Johnson?
I have.
Do you have any additions, corrections, or challenges?
No, I do not.
Anything that you want the court to consider?
Yes, Your Honor. I know the recommendation is for 6 months in jail when he only gets 3 days credit, but I'd like the court to consider not sending him to jail. He's completed a Bear River inpatient treatment program, 3 months. He has a certificate of completion with him today if you'd like to see that. He's also continuing with his aftercare counseling, and he has 2 letters from his counselor. He'd love to see those. I think that he's doing well. He also participates in the Celebrate Recovery Program. He goes to that once a month, but he is, again, continuing into counseling and that sort of thing. He currently been working at J&J Online Auction here in Nevaeh County for 6 years. And he'd like to maintain that job He lives with his wife and children. They're anywhere from he's got 4 children, ages like 7 months all the way up to 10 years old. So he's a young family. He's hoping that you would consider maybe tether. I was explaining to him about the, how you cut your probation in half, and he said he didn't want to do that. He wants to do the full probation because he thinks it's going to continue to help with his sobriety. I think it'd be more beneficial for him to be in the community than in jail, so he could provide for his family and continue with his sobriety path. He's doing really well. I think there's a couple things you'd like to say. Would you like to see those letters and certificate?
The prosecution needs a chance to review as well. All right, so over to you, Mr. Johnson.
May I approach?
Yes, please. So, Mr. Johnson, your appointed attorney in this case is Mr. Prysock, and he couldn't be here today. He made arrangements for Ms. Frisbee to be here. Is that okay with you?
Yes, Your Honor.
Okay, all right. Now, you've had an opportunity to read the pre-sentence investigation report.
I have.
Did you go over that with Mr. Prysock and/or Ms. Frisbee?
I did, Your Honor.
Do you have any additions, corrections, or challenges?
No, Your Honor.
Is there anything that you want to say on your own behalf?
The only thing I'd like to say on my behalf is that this is the first time that I've taken my recovery proactively. I've been in this court multiple times for the same offense, and it's always just been escaped by. I went to rehab. I did my 3 months. I do go to Celebrate Recovery in Mount Pleasant every week. Therapy, peer recovery coach. I want to do this right this time, and I want to continue to understand why I thought the way I thought and how my past traumas affected my decision making today. I'm the sole provider of my family. My wife's got a seizure disorder and she can't work. Also can't qualify for disability. I want to stay on the right path, raise my family, and show them the man I can be, not the man I was. I do also agree with the tether option if available. I've been on the tether before, and I think early on in recovery it's extremely helpful. I know it's going to cost me financially, but it's worth my sobriety.
Okay. And over to you, Mr. Dakin. Any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
No, Your Honor.
All right. So, Mr. Zero, you had a chance to meet with Mr. Johnson. Were you aware of his recovery efforts and his completion of the Bear River and so forth?
I don't recall if he had completed it before he met with me or if that happened after he met with me. But I am aware of, I've met with Mr. Johnson several times over the past several years under the exact same circumstances. He had a job at J&J auction, and his employer has always treated him very well, very supportive. Mr. Johnson has a lot of very appropriate social support from his wife and from the community. He just keeps relapsing back into alcohol and driving. So, no, I don't recall if he had already completed Bear River before he met with me or if that was after he met with me. He's always very respectful, desperately wants to maintain sobriety, but there seems to be some common triggers that trigger his drinking, and he has a tendency to relapse after a year or two of sobriety and ends up finding himself right back in the same situation.
So, Mr. Johnson, you're looking at your record, you've got, it's like, pre-domestic violence is, one of them being a felony. Were all those, alcohol related as well? Were you drinking when you committed those crimes?
Yes, Your Honor.
All right. What's the most amount of time that you spent in jail?
3 months for a possession charge, a couple years ago. That's all I can say. This is the only time I've taken this proactively. I've tried to get ahead of it, and I've explored with a therapist, with a counselor, and through 3 months of rehab what's causing this, my past traumas, my past issues that have become co-occurring disorders. I want to continue with my therapy, continue with my recovery coach, and do this differently. Not just tell you that I'm going to stay clean. I want the tether for liability for as long as needed. I feel like maybe that's kind of a crutch to lean on, but to me, it's just keeping me honest. Even if I have those moments or thoughts of relapse, you can, but the police will be knocking at your door in a minute. I just want to try this differently, Your Honor.
All right. Do you have any juvenile records, sir?
I had a marijuana possession charge when I was 17.
You know how that was resolved?
6 months of probation, and then I think it was expunged.
So, Mr. Zerif, I see that the face sheet, it says he does have a juvenile record, but then in the criminal justice section, I didn't see anything listed for juvenile convictions.
Sounds like a 7411 situation, Your Honor.
I believe that's accurate, Your Honor. I think it was a possession charge, successfully completed juvenile probation, and it was expunged.
Okay, so the face sheet should reflect no juvenile record then?
Generally, if they were convicted even as a juvenile and served a term of probation and it was expunged, that would still register as having a juvenile record. So it should be added to the criminal section of the juvenile. Even if it was expunged, it would still be noted in the report.
Okay, so maybe we should amend the report to add that he was charged with a possession in juvenile court, and then it sounds like it was ultimately dismissed for successful completion of probation. So I'm going to put no juvenile record because he wasn't convicted on the face sheet, but then we'll add it in the criminal history part as being dismissed. All right, so the court recognizes that the advisory guidelines would suggest a sentence between 0 and 13 months. The courts can exercise my discretion sentence consistent with the advisory guidelines. Consistent with the plea agreement in this case would be the sentence of the court. This defendant served 90 days in the Revoked County Jail, and we'll give him day-for-day credit for his successful completion of the inpatient treatment program at Bear River. In addition, I'll give him 6 days credit for the time that he spent in jail before going to Bear River. The court is going to place him on probation for 2 years. There is a $30 a month probation oversight fee for regular probation, $60 a month for electronic monitoring or tether. There's a $100 fine. There's a $100 fine. There's a $500 OWI fee. There's a $68 state cost assessment, $130 crime victims' rights fund fee. Restitution amount of $150 payable to the Revoked County Sheriff's Department. I think that an alcohol tether would be appropriate for Mr. Johnson, probably at least starting out for at least 90 days, kind of review how he's doing after that. Mr. Johnson, I can tell you that if you go back to drinking either on the tether or even after you're still on probation, you're going to spend a lot of time in jail, if not prison. Typically, people in your situation get 6 months in the county jail. And I do take into account that you did on your own court, go to the Bear River, that everything indicates that you did well there. It sounds like you're actively participating and taking full advantage of aftercare, which is another good sign. So I don't want to set back that momentum that you have going, but you are far from out of the woods in this case.
Yes, sir.
And Mr. Zerk indicated you've demonstrated the ability to go extended periods of time, maybe without drinking, but certainly without violating the law. But you do have that significant relapse history, and it's going to take more than the 6 months that you've kind of been working on it in good faith to kind of get through all those deep-seated issues that you've identified. But you're on the right track. So, of course, you can give you a chance, but you get one chance.
Thank you, Your Honor.
Blow it, it's jail time, big time.
Yes, sir.
Can you pay your financial assessments today, sir?
How much is the total?
It's probably $1,000.
Not today, but within a week.
Okay.
You can give him 30 days, Honor, just in case something comes up.
Yeah, I'll give him 30 days to pay. You do have the right to make application for to appeal your conviction sentence. If you can afford an attorney, the court appointed attorney to represent you on the appeal request from lawyers who file with the court. In 42 days, you also have the right to petition the court for early discharge of probation if you successfully complete after your term.
You know where to go to get this other one.
No, I can't.
So go back.
Hour 2 of TCF Live. I hope you're enjoying the show so far. I know I am. Let's do this. Let's go over to the thumb of Michigan Huron County, Judge Prill. In scanning through his hearings this morning, it seems like his audio has been fixed, but let's find out for sure.
Two files, 267488FH, as well as 257373FH. Time and day set for arraignment in the newest file. Time and day set for bond hearing in the 25 file. The defendant is present, represented by Attorney Michelle R. Siv. People are represented by Assistant Prosecuting Attorney Alexander Mahoney. Ms. Siv, let's begin with the arraignment first, please. Have you received a copy of the information that's been filed in this case? Have you and your client had the opportunity to review it and waive the reading as well?
Yes, totally about that.
All right. Is there a plea offer at this time?
There are still negotiations in regards to a plea offer, but at this time, though, we would ask that the matter be set for pretrial down about 30 to 45 days.
Mr. Mahoney, any objection?
No objection at all.
Thank you. As to all counts of the information, on or about November 16, 2025, Village of Michigan County, Huron, how does your client plead? Not guilty pleas will be entered on behalf of the defendant relative to both counts. We will schedule a pretrial for September 21 or 28. So. September 21 at 9 a.m. Bond was previously set in this matter at $8,000, 10%. It's posted, and now we'll begin the bond hearing. Mr. Mahoney, you may proceed.
The bond motion, Your Honor, was at the time that the second case upon which the defendant was just arraigned was still in the district court. So this is only filed in the 307-373. This is the people's third motion to revoke the defendant's bond. I would note that the defendant is before the court remaining on bond for the case that was already pending here, in addition to the case upon which he was just arraigned. One of the conditions of the defendant's bond, as the court is aware from 2 prior bond violation hearings, is that he comply with drug and alcohol testing at a chance to change. On July 28th, Jamie Wood of Huron County Pretrial Services submitted a bond violation report regarding the defendant in that he has failed to comply with those the testing requirements of his bond, and that at the time of the filing of this motion, he had missed 5 scheduled drug and alcohol tests since his prior contempt proceedings, that being on July 8, July 10, July 15, July 17, and July 27 of this year. The people would move for the admission of Ms. Wood's report, as well as Exhibit 1 that's attached to the filing under MRE 1101, and would argue that the defendant is once again guilty of contempt of this court for violating the requirements of testing. Does the court have any questions of me? I don't. Thank you, Your Honor.
Any objection relative to the motion?
Nope.
To the attachments?
No objection, Your Honor. And Mr. Smith is actually willing to acknowledge the bond violation.
Very well.
I can mention that soon.
Sir, will you please raise your right hand? I swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. Please state your name. Mr. Smith, did you hear everything that was stated on the record just a moment ago regarding bond? And it's been alleged that you have missed a significant amount of testing, and this is the 3rd motion for a bond violation. Do you understand that?
Yes, sir. There's lack of funds. They're trying to test me every other day. I go and I have negative tests, but then it's one day on, one day off. I can't afford $60 a week. I'm trying to pay my bills and trying to get groceries. I'm going to the church for food. It's hurting bad. And I lost my job last time because of the 7 days. I couldn't afford work release. I'm out here trying. I'm not been in this court system. I respect the law, sir. It's really hurt my life out here. I'm trying my best. I can give you, and I can go test right now. I'm not out here doing anything. I'm wait for this trial to be over with so I can get this behind me, sir, and move on. I've lived here 25 years. I obey the law. I've been a good citizen. I don't have any problems with your court or the law. It's not, I just don't have this lack of funds.
Court finds that the defendant has indeed violated the terms and conditions of this bond. He's admitted as such. Ms. Siv, any comment relative to bond since the court has found the defendant in violation of bond, he is held in contempt. And is there anything you'd like to say before the court sets a new bond or disposition relative to contempt?
Well, Your Honor, as Mr. Smith stated that the issue here is financial issue. He doesn't have the funds to pass that often. If the court were to impose a higher amount of bond, most likely probably couldn't post that. So I would ask the court to consider that Mr. Smith is here. I do have paperwork. I did show Ms. Wood and Mr. Bahani documentation in regards to him being at the hospital yesterday at McLaren in Nevaeh. So I just want the court to be aware of that as well. But he's here today. He's taken responsibility for what he has done, and so I would ask the court to not give him a higher bond nor to revoke his bond. I know the last time was 7 days in jail that he had to serve, so I would ask the court if the court is going to order any jail time that is be around that same amount.
Is he working at all?
Not at this time, Your Honor. He was looking for employment, but I did say that he lost his employment at Hungry Howie's because of the last.
We as landscape bring me on to your jobs when they can bring me in. So I do have that going on. We do have another job coming up next week. So I'm trying. I really am. It's not because I disobey your laws or anything or have any.
Not my laws, just the rules of the court.
Yes, sir. I understand.
Mr. Bahani, your position.
Your Honor, this is the 3rd violation. The defendant's well aware of the requirements of his bond, and the people are not persuaded by his rationale, because at no time has he gone to the pretrial services officer, Ms. Wood, and said, I can't afford this. That's not what's happening. She's just not going, and there's not contact with Mr. Smith. So we ask the court to revoke bond at this time.
Before the court makes a decision, the court sua sponte calls Ms. Wood. Ms. Wood, would you please step up to the witness stand? Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So,
I will.
please state your name.
Jamie Wood,
Ms. Wood, your position,
Pretrial Services.
and you monitor Mr. Smith.
I do.
And did you hear a moment ago, Mr. Bahani speaking of, as an officer of the court, he stated that the defendant has not contacted you regarding costs, hardship, or anything like that. Can you explain all that to the court, please?
He has contacted me. I don't think Mr. Bahani is aware of that. I did put that in my report.
Okay.
We did meet, I have the date here, on the 21st, July 21st. Mr. Smith did come into my office and we did talk about testing, and I did switch his testing to 4 times monthly. But he had already missed so many tests. I said, no more missed tests.
So you reduced the testing to essentially one time a week.
Mhm.
How much is that? Yes.
Yes.
How much are the tests?
$25
$25
per test. Yes, but that was the 21st that I met with him. And again, Mr. Bahani wasn't aware of that. Would have missed a test. So the 21st I met with him, he did test the 22nd, and they did get him again the 24th. They did test him again the 24th, and then the 27th he did miss. I'm not sure why they tested him that much in those 2 days, but it's random.
Sure. Any positive tests?
Not since he's been lodged. There was positive tests prior to that.
I see. Do you have any recommendations relative to bonds since you've worked with this individual? If there is a bond?
I don't really have any recommendations when it comes to the amount. I do suggest that he does need to continue testing. Obviously, these are both felonies that he's on bond for. So he does need to continue testing, and it's going to be at least once a week. But it is random. I have it down for 3 times for alcohol and 1 time for drugs. So it could be 2 times in 1 week and then not test for a week and a half. But he had told me prior to that he was going to give them $100 so they had money there. So when I talked to him on the 21st, he should have had the $100 at chance to change. So he just didn't appear.
I just got paid that Monday and I was going in there.
Mr. Bahani, do you have any questions?
I have no questions, Your Honor.
Is it?
So you had indicated that he said he was going to give a chance to change $100?
Correct. That's what he advised on the 21st, is that he was going to prepay them $100 so that he had the money there. So when he tested, that it would be paid.
And the last positive test you said was before he was lodged. So was that around what time would that have been?
I actually would have to look back in my notes to see when the last positive test was. He was positive for buprenorphine on, it was May. I'm just looking. There's no scripts on file. So that would have been positive, but he was also so the only 2 that I see in May.
One to be in the,
excuse me.
Sorry.
There was a buprenorphine positive without RX on file. That would have been May 20th and May 23rd. And And at this point, that's all I'm seeing.
Have there been any positives for alcohol? No.
Not recently. I would say not within the last 3 or 4 months, no.
Thank you. I'm not anything.
Your Honor, I just apologize for my misstatement to the court. I was basing my statements on Ms. Wood's report. I did not realize that she had an off-the-record or an outside conversation. However, my point to the court was going to be with that when individuals do communicate with Ms. Wood, that she bends over backwards to accommodate them on bond, just as she's testified on the record today, that she cut his testing down to the bare minimum of 4 times per month, even though we're looking at 4 felonies, one of which is definitely alcohol related.
You need not apologize. Ms. Sid, do you have any other? Okay. Well, this is the 3rd motion, and court understands that the court has to consider finances of individuals as well, but to the bare minimum of 4 times per month, which is frankly not really testing at the end of the day. It is, but it isn't, because certainly over 30 plus days, a lot of things can happen. Fortunately, we've not had significant positive tests since the last time the defendant was lodged, but court sees through its orders relative to bond. As a result, in this case, the court is going to continue the bond. However, based on the contempt, the court is going to order the defendant serve 30 days in the county jail. No credit for time served. He is to report to the jail forthwith. He's not entitled to work release because he's currently not working at this time. And once the 30 days has been served, he shall be released under the same bond conditions, but he is ordered to meet with Ms. Wood upon his release from the county jail. So as soon as he's released, he is to meet with Ms. Wood to reschedule and get the testing back up and running. That is the court's decision. That'll be all. Correct.
Hour 2 of TCF Live, about halfway through the show now. I hope you guys are enjoying your morning so far. Let's go to Texas, say good morning to Judge Stevens, spend a little time with him, and then I think maybe we'll try something new after that, but we'll see.
Must be your calling. That's okay. You do. It's like your hair long. Use water. Yeah, that's what water on. Normally, that's what his hair looks like. Yes, sir. Second degree felony of burglary of a habitation here, and that's old. 2 years.
Yes. One was a situation where he had moved, and they indicted him later. It was not somewhere he was arrested the day of.
No. It got my attention because that's old. Yeah, that's getting old.
And last time we reset to look at discovery, we've looked at discovery. There's an offer on the table. We want to put this in a trial document. This is a trial.
Say that again.
So the last time we were here, we asked for some time to go over discovery. We've looked at discovery. We've got the state got an offer.
Okay. So what are you asking for? Trial doc?
Yeah.
These are police sections.
Oh, yeah. No.
Before we can place it on the trial.
What's his criminal history, Michael? None? He's none? And you are, okay, he knows that.
Yes.
Okay, so if he's found guilty, if you're found guilty, even if they give you probation, it's not deferred. They can give, it's a conviction for the rest of your life.
Yes, sir.
Okay, all right. As long as you know that, that's your choice. See, complaint, she'd gone, severed backdoor bones. We found a print. The print was identified by to Von Frederick. He was interviewed and denied any knowledge of this or why his print would be there, and offered no explanation of why it was there. That is a mystery, isn't it? We can explain that our daughter or son do not know Frederick either. That is weird.
Usually fake a first and investigate because. And they will. Right here, yeah.
All right.
No, it's not on your side. All of them. Yeah. This. Oh.
The question is, what did they compare the print with? Hey, John, what did they compare the print with? He's not from around here. What did they compare it to? It's not on your driving license. Oh, Sheena. That's cool.
Quiet, please.
Hey, Michael. Oh, you got this one?
Yes, sir.
What did they compare the print with? They're real short. About what yeah.
Looks like. Whatever. See you.
There's mysterious.
What's the elimination plan software on board is especially entered into APHIS.
Oh.
Let's see, doesn't say that's where they got that one from, though.
Well, why is it in APHIS?
They always enter them into APHIS to look for things.
Yeah, but once his print in there.
I don't know that it was. That's what I said. I don't know if that's where they got that from. Trying to see where the report is that where the person says they got the punch shot.
We wake up,
Oh, he does have what he does have. For trespassing charge.
We didn't go with this.
Yeah,
Leased.
Yeah,
Okay,
in Harris County,
okay.
criminal trespass
There you
there.
go. Okay.
So there's a prior arrest out of Harris County.
Misdemeanor, that's why. But so he was in the system from that.
What happened in that?
Dismissed.
What was the date?
2022,
Okay.
February 7th of 2022.
But he was still in the system.
Sorry, it's set for trial.
Okay. Teresa.
That we'll do. Israel Gallery.
So it's from.
Israel Gallery. 26 CR1231. You're Israel Gallery. You're charged with assault, family violence by choking, which is a third-degree felony if found guilty, which means facing up to 10 years in prison. Oh boy, we got a prior conviction, huh? 2015 out of this court. So you're not eligible for probation in front of a jury. So this third degree, if this prior conviction of burglary of a habitation is proven true, then it is enhanced to a second-degree felony punishment. So you're looking at up to 20 years in prison and no parole, no probation is eligible by a jury. You understand? Or you understand?
Yeah, yes, sir.
You still on 9th Street in Port Neches?
No, I'm at 4110 Big Bend.
Okay, say that, we gotta keep up with your address. What is it?
4110 Big Bend Avenue, Port Arthur, Texas.
Okay, it's 4110. What did he say? He's
Big Bend.
Big Bend.
Big Bend.
Okay. Near the mall.
Yeah. This time.
340. You're 347. The woman who was injured or let's see, the other, where is she located? Do you know?
She had 9th Street. 4 exits.
Okay. Do you understand you cannot have any contact with her?
She removed the order against me, the restraining order. That was.
I'm sorry. That's my order.
They have restricted.
I don't know. No, that restraining order was something else. My order always in this, my court order as a condition of bond is you cannot have any contact with the victim. Are you contacting her? Are y'all living?
No.
I want to know because your bond will be revoked and you'll sit in jail until we can finish this.
No, sir.
This restraining order, that thing is something else. That's not my restraining order. My condition of bond is always the same when it's family assaults, when somebody strikes someone like this. It's striking about the head and impeding the normal breathing by applying pressure to throw, squeezing somebody's neck. That's what you're used. That's what you're accused of, which is attempt to kill people. And anyone who has contact with a victim under my court order, like you have in all cases, don't contact the victim. I'd like the state to check on that.
Yes, sir.
Because something doesn't smell right. He was too anxious to talk about what that order is not my. That's a different thing altogether. My order is a bond order, which is a separate one, which says you cannot have any contact with the person. So if I catch you doing it, then you'll sit it out in jail so we can figure this out. Do you understand?
I got it.
And no one on your behalf can contact her about this case. Because too often people try to put pressure on the victim and make them feel like it's their fault when that's not the way the grand jury wrote the indictment. What do you want to do today?
Yeah, this is an initial, so we can get some time to go over discovery.
Yeah, 4 weeks.
Perfect.
Arturo Puente.
Yeah, I'm on this. I'm anywhere, so outside.
25C01143. Arturo Puente.
I'll give it to you. Hang on.
And I'll be outside.
Okay.
Okay.
Your Honor, this is, we've gone over discovery. I talked to my client. The state's made an offer. If we can get some time, he wants to think about the offer. If we
It's
get
a year old, John.
Yeah, I know, but this is only our second time we've just gone over
Well, I
discovery.
it's a year old.
Oh, I don't know why it took that long to get to court. I have no idea. That's.
Where do you live now?
No address on file, 2259 Orchid Street.
I don't understand why it took a year to get here.
We have here.
I mean, this is 2259 Orchid.
Yeah.
Is what is the indictment. You were indicted August of last year.
The restaurant so far. Main bond.
Legal. Yeah, last time we were with our initial appearance, Your Honor. So
but that's where you live.
Yes, sir.
Or where do you work?
Working in refineries.
What do you do?
Painting.
Painting?
Yes, sir.
You said 4 weeks?
Yeah, I think we're being resolved, but I guess.
Good resetting, John. Thank you.
All right. And then you're pretty bad.
Before we read.
All right, friends, we'll keep an eye on Judge Stevens' court, but I want to go back to Newaygo County and Judge Springstead, where he's going to do a sentencing, and this is for a lady named Miss Carey, who we saw a few weeks back in his court, and this was an OWI causing death. So let's see what's going on with this.
All right, this is case number 2613711FH, People versus Samantha Carey. Ms. Carey is here for sentencing on the 1-year misdemeanor of moving a violation causing death. There was no previous sentence investigation report prepared in this case. And so that's over to you, Mr. Gray. Is there anything that you want the court to consider before the court imposes a sentence?
Yes, Your Honor. There was a Cobb's agreement before where my client would serve 1 year in the Muskegon County Jail. Work release would be authorized. I have made contact with the Muskegon County Jail administrator. My client has done that as well. She has everything in place for her to report to jail in Muskegon and to begin serving her sentence. She does have a work release authorized and set up through the county jail. She asked the court to impose that sentence as recommended. I know she has a statement that she'd like to make to the court as well as to the victims in this case, and I believe there is a victim impact statement that's also going to take place.
All right, so Mr. Gray, when do you know when Muskegon County is ready to take her?
They can take her at any time.
Okay. All right, then I guess, Ms. Robinson, do you want to have the victim's impact statement before or after Ms. Carey's statements?
Your Honor, I think it would be appropriate for the victims to have the opportunity to speak first. That is Craig and Sharon Verberg.
Okay. Craig and Sharon Verberg, did you want to come forward?
Ms. Sharon Verberg is in the blue tank top. Looks like she has prepared it and has her agent doing it for her.
Okay.
As is allowed.
Okay.
Just right up there so Mike can pick up.
What's your name, ma'am?
My name is Deanna Traxler.
Okay.
I am Sharon Verberg's friend.
Okay. And she's prepared a statement that she wanted you to read?
Yep.
Okay.
She has.
All right, you go ahead.
My son Alex, a quiet, caring young man, was killed on May 24th, 2024, as a result of the choices that Samantha made. What you did tore my life apart. I don't know how to live my life now. The pain I feel is so excruciating. No words can express how raw my pain has been and still is. And I don't know if it will ever lessen. You changed my life and the life of my family forever. I understand that people make mistakes. I hope you have learned from the mistakes you made that night, and I hope you never do those things again.
Thank you. Ms. Roberts, anybody else that wanted to address the court?
Your Honor, Mr. Dakin is just stepping out to see if Mr. Craig Verberg is here. So while he does that, I will be happy to read at least or speak out from his impact statement where he had originally filled that out. I know he had said he wanted to be included. I've met with Sharon and Craig multiple times. So if he is not here to make it today, I'm happy to make that as part of my allocution just on his behalf and what he has said to me. So I know that typically that would go after the defendant. So if you would like me to do that, now I can, otherwise I can do that when it is typically my turn. But it looks like Mr. Craig Verberg is not here to speak, Your Honor.
Is that correct, Sharon Verberg, that Craig was not going to make it today?
I haven't talked to him. He was supposed to be here. I don't know what maybe traffic got out. I had to talk to him.
Okay, all right. All right, so why don't we do this? Why don't you, there was things that were shared by Mr. Craig Verberg in the victim impact statement. Why don't you do that as an impact statement now? And if he shows up, he can supplement that or he can say what he wants to say. But let's take care of that now.
Thank you, Your Honor. Your Honor, as I said, I have met with Craig and Sharon multiple times. I cannot even begin to express the loss that he has indicated he is suffering as a result of the loss of his son. I understand that, you know, with a car accident, that he knows that Miss Carey did not want, you know, it was not her intention that his son lose his life. However, he has indicated that regardless of what that intention was, as a result of her actions, he will never have his son back. That he lives with that every single day. That no matter how much, and he has said, you know what, she goes to prison, it doesn't do anything. Nothing changes the fact that I no longer have my family. Is his biggest thing. And I know that he has expressed to me repeatedly that the only hope he has from any of this is that she understands the severity of what she has put his family through and the extent of the loss that they have suffered as a result of her actions, that he hopes more than anything that she takes that seriously, that she does not treat this as, you know, getting slap on the wrist or even an unfair, you know, punishment, that she understands how bad this was and that she never put any other family in the position of risking that loss again. Mr. Herbert did just walk in, Your Honor, so. This is your chance. Oh, you stand here, you can. No, you're kind. There's a microphone. So
Your name, sir?
Craig Allen Verberg.
Okay, and you're the father of the victim, is that correct?
Yes.
Okay, you can go ahead, sir.
I just wanted to say that losing my son was probably the worst thing I've ever had to go through. That being said, I hope this girl can get her life together going forward. My son was my best friend. He did so much. He never asked for anything from anyone. There were several times when I tried to help him and he told me, Dad, I don't need your help. He could take care of his own thing. Sorry, this is hard. I don't know what else to say right now.
Okay, thank you for coming, sir. All right, so then over to you, Ms. Carey. Is there anything that you want the court to consider before the court imposes a sentence?
Yes.
Okay.
Yes. Dear Alex and family, 2 years ago I was behind the wheel when your little friend died. That fact has not left me and it never will. Writing this letter is not something I've been able to bring myself to do until now. Not because I was avoiding it. Accountability, but because I could not find the words that felt adequate to what happened. I'm still not sure I have them. But I owe you this, and staying silent feels like another failure. I cannot fully imagine what these 2 years have been like for you. There's a person who was no longer at the dinner table, no longer answering the phone, no longer there for a milestone. And ordinary days don't seem to matter until they're gone. Grief like that doesn't move in a straight line. There are probably mornings that feel manageable and afternoons. where something feels small, like a song or a smell, or someone's laugh brings it back without a warning. You've been carrying this weight since the day of the accident, and you will carry some version of it for the rest of your lives. I know that, and I think about it. I caused this. This accident happened because of a mistake I made, and a person died because of it. There's no version of that sentence that lets me off the hook, and I'm not looking for one. I was behind the wheel and I made an error of judgment. Whatever pressures or circumstances existed in my life at that moment, none of them explain what happened or reduce my responsibility for it. I am not asking you to understand what I was going through. I am telling you I understand what I did. What I can control is going forward is how I move through the world. I have thought about the choices that led to this moment more times than I can count. I pay more attention now to then what I'm doing, for how I drive, and every choice I make from here on out. My whole mindset has changed and opened my eyes up to everything. I know what it means to be responsible for something as ordinary and dangerous as getting behind the wheel. I think about your family every time, and that is not a small thing, and it shapes my behavior every day. I am committed to carrying that awareness, not as a punishment, but because your loved one's life mattered, and this is the least I can do to honor that. I don't expect forgiveness, and I'm not asking for it. What I'm asking is that I have not moved on as if nothing's happened. I carry this with me, and I am sorry for the accident, everything that it cost you. With sincere regret, Samantha Carey.
So then back to you, Ms. Robinson, anything that you want to say?
Your Honor, I think that the parents and the statement that I made on Mr. Verberg's behalf before he walked in summarize pretty well for the court the position. I would just like to put on the record that this offer was discussed extensively with the family before the reduction was offered, but for their hope that Ms. Carey will take this and move on and learn from it, the people would likely not have done that. So I do want to just reiterate that victims have expressed to me that the main thing they want out of this is that Ms. Carey learned from it, and as Mr. Verberg said, that she, I think he's was able to get her life together and really make something of it. So I would just mirror that and hope that this is a learning, I don't even want to say opportunity, but this is a lesson that is not wasted at any point in Ms. Carey's life. So I would ask the court to sentence pursuant to the agreement, and we'll all hope that we never end up back here. Thank you.
All right, so Greg and Sharon Verberg, thank you for your comments today. You suffered what no parent can even let their mind go to, is what's lost to what it feels like to lose a child. I've been a defense attorney, I've been a prosecutor, I've been a judge, and I can tell you that what I see in Ms. Carey is not fear or upset about what she's facing going through to spend the next year in jail. I think she's really sincere in that she really feels bad and takes to heart, and that taking your son's life is something that's going to haunt her for the rest of her life. I don't think she's putting on a show. I don't think she's crying for herself. I think she's crying for you guys, and I don't see that a whole lot. So I do have letters from people in her life that all echo the fact that she's kind, respectful, compassionate. She's been working the same job for a long time. So she's got all those things going for her. And it seems like she's going to be able to get through this and do the sort of things that you all hope that she does. Those things don't change the fact that there is a plea agreement in this case. So therefore it is the sentence of the court that Ms. Carey served 1 year in jail. Arrangements have been made for that jail sentence to be served in Muskegon County. The court does authorize the work release program as long as she abides by all the terms and conditions of that work release. And Ms. Carey, what that means is that if you are not working, you are in jail. And I don't expect that you would take advantage of that. I've had people in the past that have. So for some reason, there's a shutdown. You're in jail. If you get out early, you're in jail. If you're not working, you're in jail. And that sentence will start today. It's 10:30. I'm guessing that you could be to the Muskegon County Jail by noon. There is a $68 state cost assessment, $130 crime victims rights fund fee. And you do have the right to make applications to approve your conviction sentence. If you cannot afford an attorney, the court appointed attorney represents you on appeal. The request for lawyer must be filed with court within 15 days. Can you pay your financial assessments today?
Yes, sir.
All right. All right. That's all for today.
Unfortunate situation there for sure, obviously. And you tell me what you think in the chat, but I walk away from this thinking not the devil. Somebody who, made a unfortunate choice and decision, and somebody lost their life in it, but I don't see the devil there. So maybe there is hope for that one. I want to take you to a new court for this channel anyways, but before I do, I want to make a shout out to another YouTube channel because this person turned me on to this court, which I didn't previously know existed, and that is April Searing. Now, April does a late night show where she covers court and does some body cam stuff and stuff like that. It's a quirky community that she runs, but quirky in a good way. So if you're up late at night and you're looking for some court to watch, go check out April Searing. And I'm going to drop a link to her channel in the chat right now. And if you're not subbed, go sub. The one thing I like about her community is it's always very welcoming. Every time I show up there, which isn't often, it's just when I can't sleep, I might check in. They're always very welcoming. They know who we are, very friendly, just like this group. So do check it out. And yeah, great. Gigi just said April is great. So if you're not already subbed there, go sub. But she introduced me to North Dakota and Judge Nick Thornton. So let's check that out. First time on this channel.
Here's personally pro se without counsel. Mr. Rasmussen, were you present in court when your rights were read?
Correct, yes.
Do you understand those rights?
Yes.
You, sir, are charged with an infraction only, and that changes some of the rights from the rights video. And I'm going to explain how your rights differ because of the nature of your charge. An infraction is punishable by a fine only. And because liberty is not at interest, because you can't go to jail, your rights to a trial are slightly different. You still have the right to a trial, but you don't have the right to have a trial by jury. It's a trial to me as the judge. So in that respect, your right to a jury trial is limited. You also have the right to counsel. But because jail is not a potential consequence, the Constitution and the Supreme Court's interpretations of the Constitution don't require the court to appoint a public defender for you if you request one. You're not eligible for a public defender for an offense that is not punishable by jail. And so what that means, sir, is you still have the right to counsel. You can hire a lawyer of your choosing if you wish. You can represent yourself if you wish, but you do not have the right to counsel at public expense. you understand how your rights are slightly modified because of the nature of the infraction level charge that you're facing?
Yes.
Do you have any questions about either the rights video or how I have explained they're different?
No.
All right. Have you received, well, first of all, what's your plan for counsel? Do you wish to represent yourself or do you wish to hire a lawyer?
Myself.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No.
You understand that you can change your mind at any time and hire a lawyer if your case is still pending?
Yeah.
Court will find a knowing and voluntary waiver of the right to counsel. Sir, have you received a copy of the charging document?
Yes.
Is your name spelled correctly on that charging document?
Yes.
You have the right to have that document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
I'm okay.
All right. So the state alleges that on or about July 24, 2026 in Barnes County that you committed the infraction level offense, unlawful possession of drug paraphernalia, namely, looks like a device used for ingestion of marijuana. Is charged that is an infraction. Infraction is punishable by a fine of up to $1,000. There are no applicable minimum mandatory penalties or court fees. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a United States citizen, a conviction can result in significant adverse immigration consequences for you. And it might result in significant collateral consequences that the court isn't required to explain. Do you understand the nature of the charge and penalties as I've read them?
Yes.
In an infraction case and misdemeanor cases, I am going to take a plea today. The plea options for you are either guilty or not guilty. If you choose to plead not guilty, the court will set your bail and schedule further proceedings. If you choose to plead guilty, there won't be any trial of any kind, and you'll be waiving the rights that were read to you before. So with respect to the unlawful possession of drug paraphernalia, how do you plead, sir?
Guilty.
Before you do that, Mr. Jackson, what would the state's recommendation be if Mr. Rasmussen were to plead guilty today?
Your Honor, the state's recommendation would be a $100 fine due within 30 days of the court's judgment. The defendant does have a prior deferred imposition for a similar offense in North Dakota.
Mr. Rasmussen, have you heard and understood what the state is recommending?
Yes.
Does that change your mind on what you want to do?
No.
Right, you understand that that's a recommendation and I don't have to follow it. I can impose whatever sentence I think is appropriate between a $0 fine and a $1,000 fine.
Yeah.
And you still want to move forward?
Yeah.
Has anyone forced you, threatened you, or coerced you, or made any promises to you in order to get you to plead guilty?
No.
Has anyone told you that you have to plead guilty?
No.
Do you need any additional time to speak with a lawyer about your case?
No.
All right. Mr. Jackson, a brief factual basis.
Yes, Your Honor. On July 24th, 2026, the defendant was in a vehicle that was pulled over by Sergeant Nathan Morton here in Barnes County, North Dakota. While speaking with the occupants, Sergeant Morton noticed the odor of marijuana. After speaking with the occupants, marijuana pipe was found. It was placed on Sergeant Morton's hood. It did fall off. The defendant did admit that the glass smoking device was his.
Sir, is that what happened?
Yes.
Are there any other facts that you want me to know about?
No.
Court will find a knowing, voluntary, and intelligently entered guilty plea. The court will find an adequate factual basis to support the plea. I've heard Mr. Jackson's sentencing recommendation. Is there any recommendation you wish to tell me?
No.
All right. Is there anything else that you want to tell me before I impose sentence?
No.
All right. The court's going to adopt the state sentencing recommendation in this case, impose a $100 fine to be paid in full within 30 days. Anything else, Mr. Jackson?
No, Your Honor.
Anything else, Mr. Rasmussen?
No, Your Honor.
That matter's adjourned. Have a good day.
Thank you.
Next matter the court's going to take up, State of North Dakota versus Ryan Gene Rasmussen, 02-2026 CR 179. Attorney Jackson appears on behalf of the state. Mr. Rasmussen appears personally without counsel. Mr. Rasmussen, were you present in court when your rights were read?
Yes, sir.
Were you present in court when I read the different rights that apply in infraction-only level offenses to Mr. Stuart Rasmussen, who I assume is a relative of yours?
Yes, my brother.
Okay. So you were.
Aw. I try to give a new judge a chance and then he deletes his stream. That seems very unfair. Okie dokie. Hour 3 of TCF Live. Let's move along. Louisiana, the board.
Order. Today is Tuesday, August 11th, 2026. The time is 8:51 a.m. We are considering revocation cases this morning. My name is Cheryl Renatz. I'll be serving as chairman of today's parole panel. And my colleagues on the panel today are Mr. Danny Byra, Mr. Pete Freeman. And we are seated at DOC headquarters in Baton Rouge. I'd like to have our staff here introduce themselves for the record.
Jesse Thompson, Carla Leeds.
And our first remote location this morning is at Concordia Parish Detention Center. And you are Mr. Marlborough.
Yes, ma'am.
Good morning, sir. Would you introduce yourself? Tell us your name and DOC number.
My name is Taquan Marlborough, 765-949.
Okay, and are you by yourself in that room?
Ma'am.
Okay, so we're here for a revocation decision this morning. Do you have any paperwork there with you?
I ain't got no, I got the paperwork that they just came the other day, they issued,
Is it called a parole revocation questionnaire?
yes, ma'am.
Okay, did you sign that piece of paper at the bottom?
Yes, ma'am.
Okay, well, based on that information, Mr. Marlborough, you're not eligible for us to appoint you a lawyer. So are you ready to proceed without a lawyer or you want to hire a lawyer?
Let's see what I want.
Okay, your case this morning has been assigned to Mr. Freeman. I'll turn it over to him.
Okay, Mr. Marlborough, I'm gonna read your violations and as we go through them, you can plead guilty or not guilty with or without a statement, okay?
Yes,
upon release, I'll report no later than 48 hours probation parole office, Department of Public Safety, which is listed on the certificate. You failed to report in person probation and parole following your release on good time. How do you plead to that charge?
I'm gonna plead guilty because I ain't had no ride, I ain't had no,
Okay. All right.
and nowhere to get.
Okay, I will submit monthly reports to the 5th of every month until I complete my supervision. I will not report to my parole officer in order to do so. I will report to my parole officer in order to do so. At this time, Agent Gillard provided evidence concerning this violation. Agent Gillard referred back to testimony number 1 when you didn't report. At the time, I asked Taquan Marlborough whether he had any evidence to present or wanted to make a statement. Marlborough stated he did not contact his officer, but did have an address to provide. So you got a new address now?
I got a new address written on my paper in the dorm. I ain't had nowhere. My grandma died from 682 Martin Luther King. That's where I came home to 682 Martin Luther King, Marksville, Louisiana. My grandma gone, so that house was, I ain't have no address to go home to.
All right. Let's look at number 3. That's the main. I will live at the address on the certificate. If I must move from this address, I will get permission from the parole officer before doing so. In addition, I will not leave the state of Louisiana without written permission from my parole officer. Okay, they saying you went to Pennsylvania without permission. How do you plead?
I tried to get in touch with him. You heard me? Because my baby mama do that CNA traveling shit. My bad. She do that CNA traveling. She was nurse. Her and my little boy was in Pennsylvania. So when I got released, you heard me, I ain't had nowhere to go. She told me to give my PO the address. So when I called him and I got in touch with him, he told me to go take up to a month. You hear me? And in that month when I was in Marksville, he put up to my sister's house looking for me, and I went there at that time. You remember I was in Marksville. So my partners hurried and got in touch with me. And they told me to get in touch with the parole officer. So when I did get in touch with him, he said he was putting a warrant out on me.
Were you in Pennsylvania when you got in touch with him?
So I went in Pennsylvania.
He said he wasn't.
He said he wasn't, but the probation officer said he was in Pennsylvania.
I told him that's why I was going to.
You ever go to Pennsylvania?
Hello?
Did you ever go to Pennsylvania?
Yes, sir.
Okay. Did you have permission to go?
I ain't had nowhere to go. I was homeless. I had nowhere to go, nowhere to stay.
So you went, even though, I mean, and it says, the parole officer said he didn't think you'd be approved for compact. And as I was an ex-compact commissioner, probably if you're not married, they probably wouldn't have approved compact.
Yes, sir. I ain't had nowhere to go at all.
Okay, so number 9, that's gonna be pretty much the same thing. I agree to visits at my residence or place of employment by my parole officer at any time. I also agree to searches of my personal property, residence, and or vehicle when reasonable suspicion exists that I am or have been engaged in criminal activity. Okay, that's the same thing. So that's you didn't have nowhere to go, and so you left and you went to Pennsylvania.
Ain't got no charges. They just trying to charge them. They really just saying a scandalous, but scandalous is a charge, but they ain't charged. I ain't got no charge. I'm on no bind. You hear me?
Right.
I'm on hold.
Okay, and your supervision fees, you were $315 delinquent. How you plead?
I'll pay that and I'll give you a good address.
Where's the good address at?
It's in the dome. I got it written down on my
where at? What state?
In Marksville, Louisiana.
May I ask you this? Why do you choose to go to work release? Why you told them you didn't want to go to work release? You shouldn't even be in front of us today. You could have went to work release.
I ain't never told nobody I ain't want to go to work release, sir. I ain't tell nobody that.
Okay. I think that's all right. So you have no problem with work release? Because I think it would give you a chance to put some money in the bank and then be ready to go. Okay. I have further questions.
Were you, let me go back to the work release, the offer of work release. The notes say that you were offered work release, but that you declined, saying you preferred to enter the Salvation Army program in Baton Rouge.
That's where I was trying to go to Salvation Army. I told my parole officer that I would like to go to Salvation Army for the remainder of my parole.
So you did decline.
No, I ain't refused. I ain't declined. I asked them, can I? Asked them in consideration. I really try to see if I was on a 90-day tick, on a tick. You know, it really ain't nothing serious.
I see. All right. Well, we have somebody here, I think, on Zoom. Is she here? We have Whitney Williams, the mother of your child, who would like to say a few words. Ms. Williams?
Yes, ma'am.
There you are. We can't see you. Your camera must be off, but what would you like us to know? What would you like to say?
I really don't know about the work release part, but I know that he did come with me. Well, he came meet me in Pennsylvania because he didn't have anywhere to go. He was staying on the street, but he did inform his probation officer. He did tell him it would take a month. He signed some paperwork to the Pennsylvania address. So I'm not sure if that was the address change paperwork or anything. And I also wanted to ask about the will he be able to go to work release and how long will he be able to go? Because I go on labor October 9th.
Okay. Well, hopefully we can address those questions when we vote.
If he just have to pay the three, I think he said $315.
Well, do you want to address the Pennsylvania issue?
I mean, as far as the Pennsylvania issue goes, he's got to do an interstate compact, and every state has different rules. Like you couldn't go to Mississippi because you're not married. So a lot of states won't let you go there if you're not married. A lot of states won't let you go if you don't have kinfolks or family. So it would be totally up to Pennsylvania whether they accepted him. I don't know whether they would or wouldn't, but it would depend on how their rules go. But he'd have to apply and pay the fee and see if his case could get transferred.
Okay, well, was that something that he was supposed to do then? Because now we resign in Louisiana.
Right, yeah, then he should have asked to go down there.
Okay.
You told me what to.
Yeah, I'm ready to vote.
Mr. Prince.
Okay, Mr. Marlboro, just due to your own testimony, I find you guilty of the violations of 1, 2, 3, 9, and 10. In lieu of revocation, I'm gonna order you to go to work release. I also order that you pay transportation costs to have you brought back to Louisiana.
Mr. Bond.
All right, I'm gonna go ahead and concur with Mr. Freeman, and I'm gonna set that period at work release at 1 year. Give you time to make some money.
All right.
Okay, and my vote is the same. In lieu of revocation, we'll send you to work release, and you got to do that for a period of 1 year.
You know what exact work release I'm gonna get?
DOC decides where you go on that.
Hopefully they'll try to make it close to where you're from.
All right.
Good luck to you, sir.
Thanks.
Alrighty, friends, hour 3 of TCF Live. Let's go back to Judge Stevens. Check in with him.
Okay, you are Corey Frank Reed, and you are charged in this indictment with theft. Just interesting thing here. States in the probable cause affidavit that they caught you with makeup and lipstick inside your underwear at the store. Interesting. That's one way to acquire those items, I guess. I guess that wasn't for you, but I don't know. Let me ask you, do you have any prior convictions of thefts?
I had a couple of them. Long time.
I think there's about 7.
No, you have 7 convictions of theft. The most recent one being 2 years ago. You're going to look at me in the eye and lie to me.
No, I should have had a couple of them a couple of years
7
ago.
convictions, sir, of thefts. 2 or more makes you a felon, charged with a felony, no matter what it is you steal. But you were subject to being a felon 5 convictions ago. And in fact, you have 1, 2, 3, 4, 5 felony convictions since 21. And 2, looks like 2 misdemeanors in 21 in Harris County. Thereafter, they become felonies, which is why you're here. And you're not eligible for probation in front of a jury. What are we doing today?
Your Honor, this is an initial. If we can get about 4 weeks, I can over discovery.
You have 4 weeks. You got 4 weeks, and he goes over into the penalty box before he leaves.
Resetting and then just.
Thank you. All right, I've got
Mr. Adams has his plea ready.
Aurora. We ready? See you wanna?
Thanks.
And
Thanks.
26. Just go over to that lady first.
And then goes here.
What? I'll bring it to the front, but she's.
Straight up. Two more times. You were. Prayers back up, but they're quite young.
That's cool.
Thank you.
Good morning, good morning. And this is the sale. The sale.
26 CR 1241 is called the State of Texas versus Aurora Class. Is it Class C or Class I?
Classy.
Class C LaSalle. And you were here with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Looks like the plan is on this evading arrest and detention 3rd-degree felony, the way she has been indicted. You're going to be reducing it to Class B.
That's right. Your Honor.
Misdemeanor of fleeing or attempt to elude.
That's under chapter 545.421. I've got a copy of the statute there.
Okay, it's not in the penal code.
That's right, Judge. It's in the transportation. And I am certain that Mr. Adams would not object to me abandoning any surpluses language in the indictment to get us to where we need to get to comport with that statute.
Any what kind of language?
Surplusage.
Say that 3 times fast.
I would happen to find it.
Okay, I'm gonna give you an easy one. I'm gonna give you an easy one. Say toy boat. 3 times fast.
Again, I have to respectfully decline.
Okay, all I want to know is we've done this before. It's not regular, but there's no doubt that this is a lawful lesser included
It's
offense.
my understanding, Judge. I've researched it in the past. It's supported by case
It's
law.
been a long time since we did this, but I just want to make sure that we don't come back because, this wasn't a legal thing to do. But fleeing or attempting to elude a peace officer seems to me, by its very nature, is first cousin to evading arrest or detention, except this one does.
Yes, that's.
There's one of them doesn't require a motor vehicle, right? You can run, and the other, this one, a person commits the offense if the person operates a motor vehicle and willfully refuses. So the evading arrest or detention. And what's the difference between them?
That's essentially what the courts have determined, Judge, that there is essentially indistinguishable. I mean, it just happens. That's just how the law is in this instance with these 2 statutes. Okay. And I will say the factual basis.
The site here, we're pulling this out of section 545.421 of what?
Transportation
code. Of the transportation code.
Yes,
that's right.
And I will say the underlying facts comport with the lesser included, Judge. It was a low speed, short distance drive after she was lit up by the police to her apartment complex, didn't endanger anybody in the public. She's got a minimal criminal history, Judge. I think a misdemeanor reduction is appropriate in this case, Judge. Not to mention this is an initial appearance. She's accepted responsibility earlier. We get to move a case, Judge. It's a win for everybody.
Anything else you want to add?
I think it's
Like a final argument there.
I think that's it. That's all I have. Just in all candor to the court, Mr. Ham has pointed out to
Yeah, I'm reading it.
Yeah, he's pointed out to me a note in the
The Court of Appeals out of Corpus Christi.
and in the annotation to the penal code here, it has ruled it was not a lesser included in all candor to the court.
You said corporate, that's not mandatory authority for us. Right, that's not.
No, we got a Court of Appeals decision that rules, but it's not.
No, I was saying the Corpus Christi court was a mandatory authority for us.
It's a Court of Appeals decision, and it's a Court of Appeals decision. It's a ruling.
There's actually two court of criminal appeals cases there, Judge. One from 2008, one from 2021.
So what do you want to do?
You can go to.
Hold on. Come here.
Sorry.
As we wait for Judge Stevens to start speaking again, full slate of programming today. Not only do we have this show now entering its final half hour, we have second session at 2:30 p.m. Eastern today, 11:30 a.m. Pacific, and we have sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. So full slate of programming here at TCF. So you get to spend your day with us. Good news.
File a misdemeanor information, and we do misdemeanors too. I guess we will take that and then dispose of it, and then this felony would be dismissed.
Yes, sir. Yes, sir. Can I get that law back so I can stick it in the file? Sorry about that. I appreciate it.
That was my law.
2 weeks, that's
yes,
fine.
that's
All right, we said 2 weeks. Thanks.
Yes, thank you.
Thank you all.
Okay. All right.
Thank you.
You have a good day, Bill.
Bye-bye, yes, ma'am.
Okay, I got one look.
Stop throwing that.
Christopher Clinton. Hey, John, you're working on some stuff, right? Good. I know, but I mean, you're working some stuff generally, some things moved here.
Yeah. Let's see. Yeah. We've been done 5 weeks.
Yeah, but you just don't do one day in 2 weeks. Keep up the. You've got momentum. You've got momentum. Good Lord. Forgot about that one.
You should have a motion to dismiss on your tablet, Judge, for that one.
Yep.
And it's just my attention when it's unusual.
Yeah.
That's more
See, I should take my leave.
names, AKA names than I've ever seen in an indictment in my 110 years as a judge or whatever it is. So.
You'll take these toys we go.
19-32815. Okay, there's a motion to dismiss, right?
Yes, sir.
I don't think justice was spelled correctly.
What did I put?
You, it looks like a, oh. Justice.
It happens.
Okay, I've signed a motion to dismiss. This case is dismissed.
Thank you, Jay.
He still
has proof until we get the Austin next work out. This
Just make sure.
go back to my. That's not it.
Oh, wow. File.
Yes.
Here, is that one?
I gotta deal with one first.
That's the quickest. 22-41053 is Sabrina Gallagher.
Yeah.
Sabrina How you doing? Well, that was a one fine stretch.
They just walk in, bro. They just missed you.
What was eight?
Judge, we have made a request about a couple of items and you can clarify.
All right, 22-41053 is Paul. The state of Texas versus Sabrina Gallagher. Back in May, the defendant pleaded guilty and was placed on probation and a large restitution amount.
Yes, Judge. And what our agreement, Judge, just to refresh the court's memory, what our agreement was that she would have 6 months, I believe, to make a substantial, I want to say $150,000 payment. And then 125. And that she would have, once she made that lump sum payment, then she would make monthly payments going forward from there. I think that maybe wasn't adequately communicated to probation as part of our agreement. And so we wanted to just clarify that with probation, that was our agreement. Obviously, given the nature of the sum.
How you gonna do? Good? Okay, because if you say it, you'll be fine, but go ahead.
Right, given the nature of the sum, Judge, that was part of our agreement, was to give her 6 months to go with that.
Yes.
And so we just want to clarify with probation. We had 2 other requests regarding her geographic restriction and her curfew. So wanted to address.
Go
those
ahead.
before. Judge Heard.
It's in this memo, right?
Yes. Judge.
Okay, then I've highlighted it.
Okay. So just to summarize though, her son plays in the band that plays at high school football games on Friday nights. And so we're asking the court to give her permission to be the transportation for her son to and from those games, obviously giving the schedule to probation so that they'll know when it is and what it is. And she would be in compliance with appropriate times to attend those games. And then the other request relates to her work arrangement. She lived right on the border of Jefferson County and Chambers County. And so we're asking the court for permission for her to be able to travel within Jefferson County, obviously, where she lives, but also the contiguous counties around Jefferson County without having to give day-to-day probation permission.
Does she have a job that she's working at that she has to travel for?
She's delivering as a second job, doing deliveries for favor. And she just said, you are obviously don't get to predict where the people's homes are going to be. So,
All right. Has anything been paid toward restitution?
She made one payment on the 6th at an amount of $52.
All right. Where to begin? One thing is, was this whole thing was fashioned. She's placed on deferred or unadjudicated probation for embezzling almost $500,000. This money was lost beginning over a decade ago. We don't charge interest, which the feds do. And I'd always, when I was in the federal government, I thought that was a more fair way of treating victims. But we are still, 12 years have passed, almost $500,000 is lost. If you add up just interest on that amount of money that's been lost by the victim, it adds up to a ton. Probably $100,000 or more. But I want the person paid back. They're not getting interest. And we're waiting on your terms. I don't like it. I don't like it. I don't feel sorry for you. I feel sorry for the victims. And I'm not satisfied that you're serious about this. But once again, you've made $50 payment in 12 years of loss. You were pilfering back in 2014 from these people. You can sense it. I'm not happy. I feel sorry for them. And I don't feel like my job is being done effectively when victims do not get reimbursed expediently. What are we waiting on?
Judge, it was a carefully crafted agreement.
What are we waiting on?
The funds to put the funds together so that we could make that payment.
When is that going to start rolling around?
November. That was when we had planned to do it. That's what we agreed to do. It's what we put on the record. It's what the court signed off on the day of sentencing. And it was a carefully negotiated and crafted agreement. The complainant was included in the negotiations.
They just want money.
I understand, Judge, and we're going to pay the money, but we have to. Getting that kind of money together is not a simple task, and so
it's the same problem for everybody who is a defendant who owes. They've got to figure it out. I would ask you, what are you asking for right now? I'm saying, please consider allowing her to modify her curfew as needed to be able to attend and transport her son for these activities. Okay.
For football games, for band.
What does that have to do with helping the victim get their money?
It's two separate issues, Judge. They're totally separate issues.
One's in whatever's her best interest and the other's for the victims. And I'm not being, just Just, again, the victim is priority to them.
We understand.
And we have orders here to get them done as soon as possible. That test, what happened on it?
Oh, he's good.
You can go. Go ahead.
Again, we fashioned this for a very specific reason and time frame.
And I made my decision for a good reason too.
And you did. You followed the agreement that we asked.
When are we going to get paid money? That's what I want to know, a commitment.
The lump sum, Judge, will be paid in November.
How much is that going to be?
$125,000.
Then what?
And then we'll make regular payments of the balance
Of
going
what?
of whatever the balance is.
Well, how many installments and when and how much per installment?
Judge, that was not part of the negotiation. It was.
I'm asking you a question, what to expect for the victim here, since I allowed this to happen.
Divide the remaining balance.
Okay, what's going to be consistent? What are we expecting in consistent payments for the victim after this?
I mean,
this lump sum gets paid in November.
Judge, I have a calculation.
Does she know? What's the master plan of making an income?
Thank you.
The victim has a right to know what's to expect when we're talking about this great loss, especially since it's not an interest-bearing repayment. It's dollar for dollar, which means they lose every day value on their money they've lost.
Yeah. If we just subtracted the 125 from that number, he's divided on that case answer question. Thank you. I think he seems like.
Okay, where's this sum coming from that we're waiting on?
It's complicated, Judge, and
I'm pretty good with math.
Want to not have it on the record. This the answer to the question.
Not on YouTube.
Thank you.
Oh, I understand.
I'm going to try to bump past this muted phase. We're a couple of minutes in the Wayback Machine. Or he never unmutes and she walks away. So be it. Okie dokie, friends. Let's do this. Keeping with this channel's promise of 9 to 11% more, Judge Boyd, let's go to San Antonio.
509 State versus Jamison Pace. Can I have parties announced?
Ready for the state.
Danielle Cranbrook for the defense.
And are you Mr. Pace?
Yes, Your Honor.
Counsel, you received all discovery. Did you review it with your client?
We have your
Court will find that the state is in compliance with discovery. Mr. Pace, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do, Your Honor.
State proceeding as presented.
We are, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with possession of a controlled substance penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have plea with the state, the court does not have to follow your plea. If the court gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yeah.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah.
Mr. Pace, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
If you're not a U.S. citizen, you will be deported, denied re-entry, and naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
I did.
According to the plea, punishment is to be assessed at 27 days in the Bexar County Jail under 1244. Did you understand that to be your plea? State defense, is that the plea?
It is, Judge.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions? Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge, you have to say exhibit number 1, including all attachments.
All right, state you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right for a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Please.
Anything you would say on behalf of your client?
We ask the court to call me.
All right. Who is Jessica Guzman to you?
My fiance.
Are you all still together? Do you all have children?
Actually, we just had a son the day before the rest.
All right. So why are you driving around in a vehicle with drugs?
Honestly, I bought the vehicle 2 days before that. And
All right. Please don't tell me that you bought a vehicle and somebody left their drugs behind. Usually people who use drugs don't leave drugs behind. Usually people who sell drugs don't leave their drugs behind. So let's not do that, okay? So what are you doing driving around with drugs in a vehicle and you all have a child or a child on the way? Because according to the stipulations, there was a car seat in the vehicle and there is a bunch of litter in the vehicle. So yes, speak, please.
Sorry, I don't really have a good explanation for it, ma'am, but once we found out that she was pregnant, I stopped using, so that's all I can really say.
But was she using?
Yes, she was.
All right, so that's a problem. So what is his criminal history?
I can those. I believe it's mostly misdemeanor, Judge.
All right, so what I can tell state, what I can tell parties, this, I'm assuming is the intent is for it to be a judgment satisfied?
It is, Judge.
This is my concern. Number 1, is Child Protective Services involved in your life?
Yes, ma'am.
They are?
Yes, ma'am.
Reason.
They actually came and saw me last Tuesday at the gym.
Oh,
Yes.
Okay, well, if Child Protective Services is in their life, I still have concerns, but maybe Protective Services will take care of things.
They already are. They've got her in a home and there's no, she can't be without supervised
Visits?
person with us.
Right, so was the baby born positive?
I believe so. Like I said, I obtained it for him and we whisked him away because he was premature. And,
Oh, yeah, they do testing when babies are born, so your child was probably born positive for meth. So here's my question. Should he be really getting a judgment satisfied, or should he be on probation to be addressing his drug issues?
I believe there's a safety plan through CPS, but he had been booked for his warrant the day after his shop.
So what is the safety plan?
I'm not sure about it.
Do we know the safety plan?
The state does not have knowledge of that, Judge.
Does everybody feel comfortable for him to get a judgment satisfied? For a child to be born positive with meth, that appears that there's using close towards the birth. So if y'all still want me to do the judgment satisfied, I'll do it. But I'm asking these questions because CPS, if somebody will come to me, because I'm going to order no contact with Jessica Guzman and no unsupervised contact with minors. And so they have to come to me and say, Judge, will you please lift this if somebody reads the order, which I don't know if they will.
Judge, the offer was made by the state and it was accepted, so I feel bound to it.
All right. So legally, what I can tell you, because I had to do research on this previously, an offer is not valid from the state until it's accepted by the court. That's what the law says. So, but I'm going to find you guilty. I sentence you to 27 days in the Bexar County Jail under 1244, give you credit for any time served. There's to be no contact with Jessica Guzman. There's to be no unsupervised contact with minors. And I'll put in CPS compliance, but we'll see what happens. Give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. You understand? This is what I'm gonna tell you about Child Protective Services. If you have no plans to be in your child's life and do right by your child, don't breeze in and out. Just let your attorney know. I have no plans to do right by my child. Drugs mean more to me than my child, and I'm just going to keep moving. You understand? All right. Thank you. Who's next?
Alrighty, friends, a few more minutes left of TCF Live. We'll probably do a couple minutes of overtime because I'm going to go to the board one more time, and I doubt they're going to get this done in 4 minutes. So enjoy a little bit of overtime.
Parole is now at Louisiana Correctional Institute for Women. Good morning, Warden. Would you and your staff introduce yourself for the record?
Good morning, Kristen Thomas, Warden.
Tara P, ARDC Manager.
Valencia Bennett, ARDC Specialist.
Lieutenant. All right, thank you. And we have Ms. Stewart here before us. Ms. Stewart, would you introduce yourself, please? Tell us your name, your DOC number.
My name is Lisa Stewart. My DOC number is 726-181.
Okay, before we get started, I'm just going to read some identifying information into the record, Ms. Stewart, and then I'm going to go over to Mr. Byron. Your case has been assigned to him. He'll introduce, we have a room full of people here, and we have some on Zoom, and he'll introduce all those people at the appropriate time. But first, let me just read this information in the record. You are classified as a first felony offender. You were sentenced January 19th, 2018, you received a 15-year hard labor for a manslaughter conviction in East Baton Rouge Parish. You do have a mandatory release date, a good time date in September. It's September 9th, 2027. Is that information correct?
Yes, ma'am.
All right, thank you. Mr. Byra.
All right. Why don't you tell us what you did to get into jail and what have you done since that would make us want to consider releasing you early?
In 2015, May 11th, Mother's Day, I accidentally stabbed my baby's father and he passed away. I take full responsibility for my actions and I can't take it back and I wish I could. But I've grown since then through the time of incarceration. I've learned to be a better person, not so angry as I used to be in my younger years of living. I also learned self-control. I also learned self-worth. I also learned how to be, I'm sorry, please forgive me, I'm just nervous. I learned how to self-control, and I also learned responsibility, and I also learned discipline. I've been working since I've been incarcerated, working towards making myself a better person. I'm so nervous, I'm so sorry. Please forgive me, I'm sorry, I'm nervous. But I'm working on becoming better in life with the parole project. Thank God for them with the tools that they have I can learn from them even more, which is sub-counseling, case management, reentry, to better myself along the process so I can be able and capable of living on my own in the free world. And hopefully I can just move on with my life and get myself together fully.
You done?
Oh, no, sir, I'm sorry. I'm just so nervous. Please forgive me. I'm so nervous. I'm so sorry. Please forgive me. I know this is bad. I know this is bad. And Lord knows, I loved George Taylor with all my heart. I've been with him for 10 long years. And I made this mistake that I can't take back. I wish that I could, Lord knows. And I'm so nervous, please forgive me. The night of the incident, we were at family members' house, which were his family members, in-laws, of course. And drinking, of course, and everything was involved. And, time passing, to make the long story short, we ended up going home or whatever. Someone was at my house that he didn't approve of. He told me to take care of it. When I got into there, I didn't do as was told. I got distracted because something was going on and it was told to me and I got sidetracked from it. Came in after, the argument started. As the argument went on, immediately people left the house or whatever the case may be. I stayed inside, and when he went outside as well with him, when he came back inside, the argument started between us. Words were said, hurtful things were said on both ends. And one thing led to another. And he attacked me, and we were having an altercation or whatever the case may be on the bed. He wouldn't get off. We were fighting, and when we were fighting, And when I finally did get the strength to get up, I ran in the kitchen and would grab the steak. That is the biggest mistake of my life. When he was coming up, I swung, I missed that one, but when he was coming, I was coming, and then it connected. And then he turned around and he said, "You stabbed me." He went in the bathroom, he was looking at it. When he came back out, he spun around, we came out, and he just fell. I immediately called 911. I swear that was never my intention. I take full responsibility for my actions. And more so of anything, I just wish that my in-laws could forgive me for what I have done, more so than anything. I'm a changed woman. I'm not that person anymore. I have 7 beautiful kids that I love dearly, and they also took a loss in both ways, their father and I. And I can't do nothing to change it, but I'm just trying my best still to this day to move forward from it and just work on the tools that I'm getting help with, for as with the parole project that can help me with the sub-counseling as well, and everything that I need to help me move forward. I'm so sorry, I'm nervous, that's all. Please forgive me.
That's good. How many years have you served total right now, as of right now?
11 years and 3 months.
All right. And the 100 hours of pre-release, have you taken that?
No, sir.
Right. And what about any substance abuse classes? Have you taken those?
I'm currently in substance abuse right now as we speak. I've taken Sisters Keeper, which is a domestic violence class. And that's all I was able to maintain while my incarceration being incarcerated at LCIW. The time I've been here, I came last year, October of 28.
One time, do you have anything to share with us about
Yes,
her behavior?
good morning.
Morning.
Like Ms. Stewart mentioned, she arrived last October, so she hasn't even made it quite a year with us, but she has already started participating in various programming with us. She actually is a minimum custody inmate with us and works at headquarters with the janitorial crew. We've had 0 disciplinary issues with Ms. Stewart since she has arrived. I know that she has met with the parole project, and I'll probably let Mr. Myers kind of go into detail on what that would look like if she were to be granted today. But like I said, she goes to work every day at headquarters, and we have not had any issues with Ms. Stewart since she's been here with us.
Thank you. All right, let's hear from Mr. Myers then.
Good morning, Kerry Myers with the Louisiana Parole Project. We're here on behalf today of Lisa Stewart. Lisa has served at this point more than 2/3 of her sentence. She spent most of her years of the a little over 11 years she's been incarcerated at smaller institutions where where programming wasn't as readily available as it is at LCIW. However, parole
Christy, do you want to take over briefly as Christy's on?
Yes.
I apologize. I don't know if it's my connection here. It's struggling a little bit this morning, but we are prepared to assist Lisa in her transition. She will have a case manager. As you see, all the support there she has at headquarters. Her case manager actually is present there in the room, so she will have a
think we're pretty well rehearsed in what he has to offer.
Yeah, thank you.
I'm Lindsay Lewin, Miss Stewart's counsel. I've spoken extensively with Mr. Myers as well as Ms. Christie, who's president of the Parole Project today. I can grab Ms. Christie from outside if you have any other questions from her. She would be Ms. Stewart's case manager when released with the project.
Thank you.
All right. We also have Mr. Jimmy Stewart, her brother, who's in support and wants to speak. Mr. Jimmy Stewart, can we get him?
Hello, how y'all doing?
Good.
I'm Jimmy Stewart. I'm Lisa Stewart brother. I was around when the incidents and stuff like that was going on. I could say the time she been in there, I've been providing money on her phone, money on her books. Not only that, I've been talking to her and giving her scriptures and stuff like that. Not only that, I see a different transition. I see that God has really worked on her life, and I see a new person because the old have passed and the new has become. And I see that she walking into her new ways, and she shows that by actions. And she's a new person, and not only a new person, a new mother. Put it like that. Me saying a new mother because she owned up to her responsibilities, and not only that, she's changed while she was incarcerated, and she worked on herself, and she take full accountability for the mistakes that she did made in the past. And we all make mistakes. I even made mistakes myself, and I could say none of us is not perfect. The thing about it is, the beautiful thing about a mistake that you learn from it and you gain from it because you know better, and you know better not to do no more wrong. So the time that she been locked up in there, I've seen a lot of transition. I've seen that she's really focused, and I see that she's really willing to take those steps. And I see that God has been working on her as well. And it'll be most grateful and most kindly if y'all grant her another chance to get everything right and do everything right this time.
Thank you for your input. We also have in favor a daughter, Miss Marlasia Scott. Hope I got that right. Who would like to speak.
And Committee Member Barris, all of the children who are present today are Miss Lisa Stewart and Mr. George Taylor's children. I've spoken with them about whether or not they wanted to say anything. I don't believe any of them wish to say anything directly to the committee, but they wanted every member of the committee present today to know that they are here in support of their mother's release. Ms. Marlasia Stewart being the oldest of her children. Is that correct? Yes.
Okay. So in favor, we have Christy Sheremy, the Parole Project, who's here, not speaking. Leah Stewart, a daughter, so in support, not speaking. Brianna Taylor, a daughter, who's in support, not speaking. McKayla Williams, a niece, in support, not speaking. Jordan Drake, a nephew, in support, not speaking. Jaden Taylor, a son, in support and not speaking. George Taylor, a son, in support, not speaking. Janisha Powers, a niece, in support, not speaking. Jared Taylor, a son, in support and not speaking. And Jalen Taylor, a son, in support and not speaking. We do have some opposition. We're going to move on to the opposition. Ms. Kira Thompson, the victim's sister, and she is opposed and on Zoom. All right, hold on a second. Let's hear from the lawyer first. I thought you had already spoke.
I'm
but
here. My phone lost service.
Well, let's hear from the lawyer.
Good morning, members of the committee. Thank you for allowing me to appear in front of you today. My name is Lindsay Blewin, and I'm the attorney for Ms. Lisa Stewart. At the risk of being redundant, I provided a full brief to the committee detailing the work that Stewart has undertaken entirely of her incarceration. This is a bit of a unique experience for me today, I will confess. I had the privilege of representing Ms. Lisa when she was pretrial. I was her public defender. I was the individual who counseled her and advised her to take the 15-year sentence in this case. And one of the things I told Lisa when she accepted that sentence and that responsibility was that if she ever needed anything in the future, no matter where I was, that I would be there for her. Lisa spent 3 years pre-trial in her case. And so I had the opportunity to get to know her very well. One of the things that was very clear to me from both the time I met her to today is that Lisa is an incredibly hard worker. Lisa has grieved the loss of her partner, George, throughout this entire process. This is a loss that she will spend the rest of her life grieving. And the impact it's had on her children is something she never forgets. Even from the time she was pre-trial, she was accessing programs at the East Baton Rouge Parish Prison that allowed her extended visitation time so that she could have access to her children. There were parenting classes and trustee status that if you obtained them at the parish prison, that you qualified for extended visitation, especially contact visitation. So she continued to try to raise her children from jail and support her sisters. After she was sentenced and transferred to Richland, she had a lack of access to available programming. However, once she transferred to Tallulah, she very quickly enrolled in all available programs and became a trustee. And we see that continued dedication to hard work continue when she transferred to LCIW just this past summer. Lisa transferred as a trustee from Tallulah to LCIW, but had no problem working her way back up. She was initially assigned to the kitchens when she was transferred to LCIW. But she worked that job hard, she applied for programs, and ultimately, as the warden has already said, she is, in Lisa's words, a status one trustee who works in this area. She is enrolled currently in substance abuse counseling. As Mr. Myers has already spoken to, she will be able to continue any of that programming while she is in the reentry program. Additionally, she's applied and begun some of her 1,000 hours of pre-release, but she still has classes to obtain. One of the most difficult things about Lisa's sentence during that particular time frame, I would say, is that COVID hit while she was actually. Lisa was in programming prior to that shutdown of those programs did delay her ability to complete these programs, and then ultimately being transferred to LCIW, she's had to re-enroll. But what you can see from her DOC history is that Lisa does not allow setbacks to then cause her to fall off the wagon. She doubles down and she works harder. The most important thing to Ms. Stewart is that she has an opportunity to get back to her children as soon as she possibly can. And one of the things that I am very, very excited about is that she has the opportunity to work with the Parole Project's reentry program. Christy is going to be her case manager. She's already met with their social worker to talk about counseling. There is absolutely additional counseling Ms. Stewart wants to continue to participate in with the reentry project. She's also going to be living there in their redemption home as well. She has a tremendous amount of family support. We want her to succeed. But I think most important, she has the structure and the commitment of the Parole Project's reentry program to ensure that she is a success. And then lastly, I would add that the world is a small and circular place. I think we can all agree. Almost 11 years ago, I was a brand new public defender representing a woman charged with a very, very serious offense. Today, I stand before you, the Director of Legal Services for the YWCA of Greater Baton Rouge, who operates a pro bono women's legal program that works with individuals who are victims of domestic violence. It is that reason I am able to be back in Ms. Lisa Stewart's life and representing her today. But additionally, the YWCA will be supporting the Parole Project's reentry program in any way that they need. We offer workforce development. We offer housing. We offer early childhood education. We offer education programming. We also offer civil legal services as well. And so we are going to be working hand in glove with Christy and Mr. Myers for whatever additional supports they need to make sure that the net that is woven underneath Lisa to ensure that she does not fall through the cracks, but instead succeeds. It's tightly woven and there to support. So I would ask this committee to consider granting Ms. Stewart parole and allowing her to begin that term. Thank you.
All right. Thank you. We have one more person who's unopposed in support. The victim's brother, Frank Taylor, has told the victim assistance coordinator that he was unopposed. All right, now we move on to the opposition. We have Kira Thompson, the victim's sister, who's here on Zoom and would like to speak.
I'm here.
All right, go ahead and proceed. Tell us what you got.
I don't feel like she should get out on early parole. My brother is gone and not coming back. And what she did was not a mistake. It was a choice. And I mean, his other daughter is living this without him. And she needed him too. We all needed him. And he stole that from us. Like, we have to go and look at a grave site. And I feel like she shouldn't get out early because she already got a slap on the wrist by killing my brother. So no, I feel that she should not get out early. I am a voice for my brother.
All right, thank you for your input. We also have Janara Taylor, the victim's daughter, who's on Zoom and would like to speak.
Hello, I'm here. I feel like she should not get off on parole because at the end of the day, yeah, she's saying that it was accidental, but at the same time, you knew when you picked up that knife, you was going to take someone's life with it. Like she said she swung the first time, you missed. Why would you swing again and you had a weapon in your hand, in your possession? I feel like at that point, she knew it was in game for him and she tried to take him out. At the end of the day, as far as those kids go, I feel like me and Kiara, my auntie, is their support. None of her family on their end support those kids or help those kids in any way, form, or fashion. Do I feel like she learned her lesson? No. I feel like she's going to have a reset and it's going to happen to someone else. They just haven't clicked her buttons yet. At the age of 13, I lost my daddy. I didn't have a voice. And I feel like he didn't have a voice either because on both parties, it was domestic dispute. I feel like if it was to come down to terms of him reporting the incident, it was either her or him, and it was going to be him. So now I feel like today I am his voice, and I feel like she has not learned her lesson, and I feel like she's just coming to terms with wanting to do this early parole, yes, so she could have another chance at freedom. My dad is never coming back. He don't have a second chance at life. She does. But at the same time, I feel like she needs to ride this whole 15-year sentence out because at the end of the day, my daddy didn't have a voice. This man is never coming back. He didn't even get the chance to attend my senior graduation. My dad missed a lot. I went through physically depression. She don't even know what I've been through when she made the mistake, or as she say, the mistake she's made. It's no coming back. Yes, it's the past, but at the same time, I have to live with that, with me losing my parent. So no, I feel like she do not have to get off on early parole. And that's all I really just have to say.
Thank you very much. We also have in opposition the victim's girlfriend, Kanisha Victor, which she is not speaking. I think, is she here? No, not speaking. Right. I guess we'll move on to questions. I do have a question. What have you learned through your time incarcerated? What have you learned that would be important?
I've learned structure, responsibility, and I also learned how to never take anything for granted, not even the littlest things. Is it okay if I could say anything to the opposition?
Make it brief.
I just want to say, I understand how y'all feel, and I'm sorry. I know it's nothing I can say to take back what I have done. I truly understand. And I hope that one day that y'all will be able to find in your hearts to forgive me. Whether it's my freedom on the line or not. I want to say I truly apologize.
All right. Thank you. McKayla, you have any questions?
I do. I have a couple. I noticed in the reports that we get, that we review, you have no disciplinary write-ups for your entire term of incarceration.
No, ma'am.
How'd you manage that?
I'm not a troublemaker, ma'am. I swear to you, I've just made the biggest mistake in my life that I can't take back.
So I also saw, what is your level of education?
My level of education, I dropped out in the 6th grade.
And what I saw was that you're on the waiting list for literacy. Is that right?
Yes, ma'am.
Are you enrolled in it yet?
No.
Right. And some of the other programs, I think you mentioned them. You are enrolled in substance abuse. That's right.
Yes, ma'am. Yes, ma'am.
Thinking for Change, you did that?
I didn't complete it due to COVID. That was one of the classes I didn't complete.
Okay, I see. That's one of the things that your lawyer mentions. Okay, that's all I had, Mr. Brown.
Freeman, you got any questions?
No, sir.
I'll ask for the executive session.
Second.
We have a motion by Mr. Byra, second by Mr. Freeman for executive session. I agree. So without objection, we're gonna, but you can keep your seats. We're gonna step out. We'll be in executive session for a few moments.
Alrighty, friends, we're going to bump past this because we're in the Wayback Machine a little bit, and we'll see what they rule before we go.
All right.
Let's go.
Here we go.
Back in regular session, it is 9:47 a.m. and we are prepared to vote. Mr. Byra.
All right. Before the vote, though, I need to put on the record that we do have opposition also from law enforcement, saying that she would want to serve, they would rather see her serve it to her good time date, which is next year, August 20th of 2027. However, today, after serious consideration, I am going to grant conditionally to the parole project for 1 year. But she must complete all the statutory required classes before she can go to the parole project, meaning the 100 hours pre-release and the literacy classes, all the statutory required programs before she goes there, and then follow up with parole project.
Mr. Freeman.
I concur with Mr. Byra.
And as do I, Ms. Stewart. You've done a lot of work, and I do hear what the victims who are here in opposition had to say, but I believe the resources are in place to help you succeed. You get out, you'll get some credit, good time credit for your the classes that you have to take. So that's going to move up, and that's a mandatory release date anyway. But I think it's imperative that the resources that have been laid out for us today is critical to your success. So today you've been granted. You got a little work to do beforehand. And then you'll go to the parole project for their programs. Good luck to you.
Huh. That's all I got to say is, huh. The board is perplexing sometimes, isn't it? You know, but I know that they have big reports and access to information that we don't have. And everything else. The Wahoo says, this does not surprise me. It kind of does me. But hey, sometimes people just get all stabby and then they get paroled. So, but hopefully it works out for her, obviously, because if it works out for her, then it works out for the community and everybody's safe. So fingers and toes crossed. Okay, we'll be back in about 2 hours for second session right here on this channel. We're going to throw it over there just as soon as I end the stream so you can set your reminders. We have Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific, so a full slate of programming today, and we'll be back tomorrow morning for the morning show, 9 a.m. Eastern, 6 a.m. Pacific. Thank you all so much for spending time with me. I hope to see every single one of you in 2 hours' time. Take care. God bless.